sentence you to life in confinement without parole.
That's f***ing horse shit. You do whatever the f*** you want.
Why are they shutting my mic off?
I'm the federal witness of the United States federal government. I demand some goddamn respect, you. All I did was trespass on property.
Ma'am, you gotta create the community that you want to live in.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good morning, this is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Alrighty. Good morning. Defendant is being brought to the podium.
Thank you, Your Honor.
Alright, he is wearing the headset.
Yes, Your Honor, he can hear the interpreter. Good morning.
Alrighty. Your name, sir?
Jason David Lara Vaca.
Jason David Lara Vaca.
Alright, sir, you're here today because you're arrested on a charge of aggravated battery, domestic violence. I have read the charging affidavit. I do find sufficient probable cause. Is there anyone here on this case? No. The Augusta National Drive address, do you have another place to go to live?
No, la verdad no.
The truth is no.
Okay, because, and I assume that, Dylan Alexander Diaz Moreno is living at that Augusta National Drive address, is that right?
Sí, señor, vivimos ahí, en esa misma casa. Yo soy el padrastro de él.
Yes, sir, we live there. I am the stepfather.
All right, well, you're gonna have to go somewhere else for the time being, either a friend, relative, a hotel, something along those lines, okay? Because he's not here, so because you're not gonna allow you to have contact with him. I'll step on the amount of $1,000. You're not to return to the 5901 Augusta National Drive apartments. You're to have, other than you can return there one time with law enforcement to pick up any of your possessions or anything you may need there. You're not to have any contact with Dylan Alexander Diaz Moreno. Not to possess any guns, alcohol, drugs, or weapons, or use the same.
Yo tengo.
All right, and I'll appoint a public defender to represent you. What's that? I'm sorry. What was the question?
Pues yo ahí cerca tengo un amigo, me tocaría decirle a él que si me puedo quedar ahí en la casa de él. Lo más seguro es que sí.
I have a friend that lives close by. I will have to ask him to see if I can stay at his house. Most likely, he would say yes.
That would be best, okay? So it'd probably be cheaper if you can stay with your friend than having to go to a hotel. Oh, this. All right, gotcha. Okay, thank you. Any other interpreter cases? All right, that was 2022 CF 6221AO.
Thank you, Your Honor. Is that the only case?
I believe it is. Thank you.
All right, thank you. Have a good day.
You too. All right, your name, ma'am?
Lilia Colquitt.
All right, counsel?
Morning, Your Honor. Ben Pallone on behalf of Ms. Colquitt. She's retained attorney Matthews Bark.
Okay, Ms. Colquitt, you're here today because you were arrested on a charge of battery, domestic violence. I have read the charging affidavit, and I do find that there is sufficient probable cause. No one here? All right. Do you have any place to go other than the Vista Oaks Court? Were you living there?
Yes, a separate residence, Your Honor.
Okay, yeah, that's what I thought. All right, so, and you do qualify for pretrial release. Does she want pretrial release, or does she want me to set a bond?
We just do a bond, Your Honor.
All right, I'll set a bond amount of $500. No return to 10335 Vista Oaks Court, number 317. No contact with, and I'll spell this, first name Vaibhav, and last name Phukela. No contact with him, no possession of drugs or alcohol, and no possession of firearm or weapons, okay? Now, you can't, do you have any stuff there at all? Personal items, clothes, anything at all at that address? Okay, then you don't need to go back there. If you do, then you can go back there one time with law enforcement. Okay, all righty. Anything else, counsel?
That's all I have, Your Honor.
All righty, thank you.
Thank you. Can I speak for 1 second?
Your name, sir?
Gary Cummings.
Mr. Cummings, you're here for a couple of things. First of all, in 2020 CF 8279AO, you were arrested for a violation of probation. There is no bond on that. And in (2020) CF 9534, you're also arrested on a violation of probation. And there is no bond on that. Do we have these other cases, these 22?
No, Your Honor, just the VOPs.
Okay, just VPs. And I'll appoint a public defender to represent you on those violations of probation.
Excuse me, sir.
Yep.
I should only have one violation of probation. It would run concurrent.
Well, yeah, but they
Then-
are separate cases, so they're running at the same time, but there's no bond on both. There are concurrent. I assume, I didn't really
I
look at
thought
it.
that they got rid of one of them, sir,
What's that?
because of the time they run out on one of them, sir. I'm not exactly sure exactly how it
Well,
went.
you can talk to your attorney about that. They can take a look at it. I mean, it looks like one of them you were put on probation in April, right? I mean, it wasn't that long ago. So we'll see. But you can talk to your attorney about that, okay?
Yes, sir.
Your name, sir?
Luis Molina.
All right, Mr. Molina, you're here today because you're arrested on a violation of probation in 2020 CF 15344AO, and there is no bond on that. I'll appoint a public defender to represent you on that violation of probation. Your name, sir?
Nobles.
So, Ms. Nobles, you're here for two cases. First of all, 2017 CF 15487AO, that's a violation of probation. There is no bond in that. And then in 2017, come on, computer's slow today. 2017 CF 15377AO, also a violation of probation. I might have read that one already, 15487. Both of those are violations of probation. There is no bond on those. I'll appoint a public defender to represent you on those. Good morning. Mr. Waters back.
Gavin Waters.
Mr. Waters, you're here for a violation of probation for the aggravated battery charge or violation of PTR charge. There is no bond on that. Your name, sir?
Mr. Valentine.
Mr. Valentine, you're here today because you're arrested on a charge of violation of probation, and there is no bond on that.
Actually, Your Honor,
believe
there's a
it.
Wait, hang on.
7,500.
It came
Oh, that's right, this is the one with Judge Allen, yeah. The bond is $7,500, okay? I'll appoint a public defender to represent you on that. It's a violation of your probation because, oh, hold on just a second, I'll get it for you. See what she says. You got a driving license suspended, grand theft third degree, fraudulent credit card, petty theft, didn't pay your monthly cost of supervision, and that you failed to comply with the do not drive without a valid DL as an order of the court. Okay? All right. Good morning. Your name, sir?
My name is Gage Chittister.
All right, you're back again today. Was the state able to get any additional information?
Yes, John, I already provided a copy to defense. May I approach?
Yes. Oh, is it? She's got it attached. Thanks, she attached it, thanks. All right, I review the charging affidavit. I do that find that there's sufficient probable cause. All right, ma'am, raise your right hand, please. Solemnly swear testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. Yes?
Yes.
You need to speak up. I can't hear you. Can you get close to the microphone?
Yes, sir.
All righty. What is your name?
Caitlin Bell?
All right, and you're the alleged victim in the case?
Yes.
All right, what do you want me to know?
I don't wish to go forward with any charges.
All right, so do you guys live together?
Yes.
All right, and so you wouldn't have any objection to him returning back to your house?
No.
Okay, now I can make it no hostile contact. You put your hand down.
Oh.
I can make it no hostile contact so that he doesn't treat you hostilely, doesn't yell at you or anything like that. All right?
Yes, sir.
Okay, you understand that, Mr. Chittister?
Yes, sir, I do, Your Honor.
Okay. He doesn't qualify. All right, as to count one, the tampering, set bond amount of $100. As to count two, battery, domestic violence, $500. I will allow you to return home, but no hostile contact whatsoever with Miss Bell, with Karen Elizabeth Bell, or excuse me, Caitlin, Catlyn Elizabeth Bell. No guns, no weapons, no drugs, no alcohol.
Yes,
All
sir,
right,
Your
no
Honor. So
use.
does that mean I'll be released today?
If you can, yeah, if you postpone, it's $500, $100. So either $600 cash and you'll get it all back, or you can get a bondsman.
Okay.
Okay?
Yes, thank you, Your Honor.
Mhm.
Thank you.
Your name, sir?
Hernandez Matthew.
This is another one that was reset from yesterday, Your Honor. I have provided defense and affidavit. May I approach?
Sure. Well, what was his name? Okay. All right, Mr. Hernandez, you're here today because you're arrested. And charged with domestic violence, battery, by strangulation, and child abuse. And I do find sufficient probable cause. Do you have another place to go other than where Brittany and the kids are living?
They moved out back to her mom's house. Her mom is in North Carolina right now. They moved out there, but if not, then my brother has allowed me to live with him.
All right, well, what I'm going to do, because I don't know that to be the fact for sure, I'm still going to say that you can't go back there. If it turns out that they have moved out, you can, because I will appoint a public defender to represent you, they can always present that to the judge and allow you. But you're not to return to, find that address.
"2217 Murdoch Boulevard."
Yeah. And you're not to have any contact with Brittany, her kids, Isabella, Isaiah, Adeline, or Dallas. I guess she said she's currently at her, wait,
That would be her parents' house, yes.
okay. So, no, the 2217 Murdoch, that's her brother's place?
Yes, he's currently moving out. It was the parents, now the brothers, and now the brother's moving out.
All right. You're not to go to that address. I will let you go back to 14045 Hunter Grove Drive. That was your address, if she's not there. If she's there, you can't be there, because you're not to have any contact with her or the kids. Understood?
Understood.
All right. As to the domestic violence, battery by strangulation, step on amount of $1,000, child abuse $100, and no drugs, no alcohol, no guns, no weapons. Appoint a public defender to represent you. Your name, sir? Your name?
Jose Marrero Torres, Your Honor.
Mr. Marrero Torres, you're here today because you were arrested. Oh, for attaching a tag not assigned. Is this the one that we had, was a possible plea?
Yes.
Alrighty.
And he has 7 days time served, Your Honor.
Thank you.
Your Honor, the offer from the state was a withhold of adjudication credit time served and court costs. Ms. Moreno would like to accept and enter a plea of no contest.
Mr. Marrero, is that correct? You wish to enter a plea of no contest to the charge of attaching a tag not assigned?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol today?
No, Your Honor.
Have you suffered from or been treated for any mental illness in the past? Yes, no? Any mental illness problems?
Yes, Your Honor.
All right, take medication for that?
Yes, Your Honor.
And you understand what's happening here today?
Yes.
Okay. You understand that by entering a plea of no contest, you give up your right to proceed to trial, you give up the right to require the state to prove their case beyond a reasonable doubt, the right to question any witnesses the state would bring to testify against you, the right to bring any witnesses that you may wish to testify for you, and finally, the right to testify or refuse to testify as the Constitution allows. You understand you're giving up those rights by entering your plea of no contest to get this case over with today. Do you need an interpreter? No? So, do you understand those are the rights you're giving up by entering your plea of no contest to resolve your case and get it taken care of today? Yes or no?
Yes, Your Honor.
All right. Finally, understand that this is punishable by up to 60 days in jail, not going to happen, and up to a $500 fine. That's not going to happen either. But those are the maximum penalties, and that the entry of your plea could be used against you in any deportation proceeding if you're not a citizen. You understand that?
Yes, Your Honor.
I do find sufficient factual basis to accept your plea. I'll withhold adjudication, sentence 7 days in the Orange County Jail with 7 days credit for time served. Impose court costs and a $50 cost of prosecution. It's a total of $301. And I'll give you 24 months to pay that to the clerk, okay?
Thank you.
Finally, I'm a direct clerk that they're not required for him to show a valid valid tag. Sometimes they'll audit that. They don't need to worry about that. Okay? Thank you, sir.
Thank you, Your Honor.
Your name, sir?
Janaya Carlisle, sir.
All right. Good morning, Mr. Carlisle. You were here today because you were arrested with a charge of aggravated battery on a pregnant person, domestic violence. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause Do you have a place to go other than the Park Hamilton Boulevard 321?
Yes, sir, I have.
Okay, because that's where the alleged victim is living, right?
Yes, but she currently left too, but yeah.
Okay, well, just since I don't know.
Yes, sir.
All right. All right, I will set bond amount of $500. You're not to return to 6,000 Park Hamilton Boulevard, number 321. However, you can go there one time. You can take law enforcement with you to pick up any personal items you may need, clothing or toiletries or anything like that, all right? Not to have any contact with Fantasia Times, that's PHONTASIA Times, just as it sounds. No contact with her whatsoever. That means no phone calls, no physical contact, no text. You can't have someone, a third party, do that. Now, there is Janae Carlisle. That's your child.
Genoa?
Yeah. Do you have a child?
Yes, sir.
And it's with her.
Yes, sir.
Okay. And the child lives with her.
Yes, sir.
All right. Looks like DCF has potentially been contacted. So if you do have any childcare issues or anything like that, then you need to go through a third party. All right, you
Yes,
can't make
sir.
that contact yourself. If DCF does enter a plan in any way, then that'll be a condition of your bond as well. Appoint a public defender to represent you. No guns, no weapons, no drugs, no alcohol. Okay? Did I set the bond? All right. Sometimes I forget. Your name, ma'am?
Jessica Dance.
All right, here for two cases, Ms. Dance. First of all, in 2022 CF 6255AO, I have read the charging affidavit and do find sufficient probable cause for the charge of possession of cocaine. Bond is set in the amount of $1,000. We'll appoint a public defender to represent you on that case. You're not to possess any guns, weapons, drugs, or alcohol as a condition of bond. And in 2022 CF 6277AO, I have reviewed the charging affidavit in that case and did find sufficient probable cause. Yeah. Alrighty. All right, if you guys could raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. One at a time, your names.
Kathy Behe.
Okay, and your name, ma'am?
Jamie Erickson.
Okay. And let's see, Kathy, ma'am, you are the alleged victim in the battery charge, is that right? And
Yes.
also the robbery, I guess she grabbed your phone allegedly.
She, yes,
Okay.
grabbed my arm, and I was concerned with my car. She was trying to wreck my car.
Does she live with you?
No,
She does not.
no,
Who, you shook your head no or yes?
no,
Okay.
there's not.
And how are you related to the case?
I'm her mother.
Right, the other young lady.
Sister. This is her
I am a
sister.
sister, and they said my mom could bring someone with her.
Okay.
She had
All
a
right.
stroke 3 years ago, and when she gets anxiety and anxious.
No problem, no problem. I just wanted to make sure you didn't have anything additional to add. You're just there for support, that's fine. Okay, well, Kathy, what do you want to tell me about her? Where, do you have any problem having any contact with her, or do you want to have no contact?
We're trying to enact a Marchman Act for her. She's not criminal, but she is not safe for herself, for us,
Yeah.
for her children. But she needs help. She's not in her right mind. She has angels and demons. She hit a wall 3 days ago and crashed a wall and died and was reborn. She had a traumatic experience just after Mother's Day. A friend of hers died, and I don't know if she's been doing drugs and what's been going on with her, but she has fallen apart, and that is not how she normally acts.
Well, the charges that she's here on, I have a couple of options. Obviously, I'm required to set bonds on the new charges. However, she was out on bond on a DUI charge. I could hold her if you think that's better. But I mean, at what point, I don't know that she's in, that, you know, she's necessarily getting what you're saying she needs here either, although at least she's being watched.
May I speak?
Yeah, sure.
We've been trying for 3 days and we just keep hitting walls that she's here and we can't get her help while she's here. We've been told about an ex parte that we could do by the officer yesterday, but then we were told no because she's in jail. She told mom yesterday in the car that she just needed to kill herself again so we could see and we could believe that she came back.
I read, that was in, I saw that in the charging app.
And we just want to get help for her, but at every turn, we keep running into walls that we keep getting the runaround. And we just want help for her. This is not her. She's.
Well, let me ask you this, what kind of, does she have the, if I said just that bonds anyways, does she have the ability to make bond?
I mean, if anybody, I mean, somebody or random ex-boyfriend's mom posted her bond the other day, but, you know, when she was released the other day, she wandered the streets and ended up on Colonial and Ferguson all night. When she was picked up, she was talking about how everyone's a demon and that she was reborn and she died to save us and that she went to the future. I mean, it's been a long 3 days that we've been trying to figure out what to do. But because she could tell officers on a wellness check, do you want to hurt yourself? And she yelled at them, no. Do you want to hurt somebody else? No. They were like, well, okay, you guys have to leave. And then, you know, and then mom tries to take her to her car that she wrecked on Sunday to get her phone. And that's when she's trying to wreck my mom's car yesterday.
Okay.
I mean, I don't know. I don't know what to do. I don't want her in jail, but you know, I want her to get
But let me ask you, you don't have a problem with no hostile contact either then? So in other words, if I tell her she can have contact with you, but it can't be hostile, you're okay with that? You don't want no contact?
correct. I would love to see her.
All right. I will, as far as the robbery, I'll set bond the amount of $1,000. The grand theft would be $100 and the battery $500. No hostile contact with, and I'm sorry, your last name?
Dance, D-A-N-C.
Okay, with Kathy Dance or with, I guess that's it in the case. Ma'am, you're not to possess any drugs or alcohol or use any?
Yes, sir.
Okay. You're not to possess any guns or any weapons?
Sir.
Okay. You can have contact with your mom, but it can't be hostile.
I don't
Can't put your
wanna-
hand on her, can't yell at her, can't scream at her, can't do anything like that. Can't take her phone and throw it out the window.
Right.
Okay? You need to recognize that you're having some issues right now. If everything that I read in here is true, and everything that I've heard from your mom, your friend, is true, you're having issues. They're trying to help you, right? And so you need to cooperate with them to try to get you the help you need, because otherwise, some bad stuff's going to happen to you. Living on the street and dealing with the problems you got is not any answer. Okay. So I will do that. I'll take no action on the other bonds. I'll leave that in place. But you're not to drive any car while you're out on bond either. No operating a motor vehicle at all. Okay.
Your Honor, she has a job in sales, she said. She needs her vehicle. I don't know how true that is.
What do you think about that? Well, her car, I mean, is her license suspended because of she probably has an administrative suspension on the DUI. I mean,
She does, Your Honor.
She does.
yeah, so you can't drive. If your license is suspended, you can't drive.
And Your Honor, I missed the bond. You said 1,000.
Yeah, 1,000, 100, 500.
Okay.
100, 500 on the battery. You know what, I'll make that 250. 250 on the battery, 100 and 1,000 on the robbery. And so if they're trying to work with you, you need to work with them. They only have your best interest at heart.
Okay.
Right? And you may be confused about some things, you know, maybe things that you think are real or not, or your perception of things is not exactly correct. Okay? So, all right, well, good luck. I'll appoint public defender on the cases. I don't know what the situation is on the DUI. Thank you, guys.
All right, thank you, Your Honor.
How do I do all that? That would have been.
And Your Honor, on her DUI, I didn't see an attorney appointed. Could you appoint
I'll
us?
appoint a PD if there isn't one there. You know what? They bonded her out, so yeah, there's a good chance that she didn't get.
Thank you.
All right, your name, sir?
John Dawson, sir.
Mr. Dawson, you're here today because you're arrested on a charge of stalking domestic violence and violation of a injunction for protection against domestic violence. This was from a probable cause warrant signed by a judge previously. And is there anyone here? Of course not. All right, as to the stalking domestic violence upon the amount of $1,500, a violation of the injunction, $1,000. Now, if you bond out, you are not to have any contact, none, zero.
Yes, sir.
Clearly, no contact with,
I'm sorry, Your Honor. May I ask a question?
yeah, you sure?
Okay, so my cousin and her sister, we were working together for me to move out. And so they told me that I could call Winter Park Police and get them to go with me.
Right.
I called them, then they arrested me. And then I was like, 'cause I was-
Well, when did you call, when did you call them? You called them when this warrant was already out for you, the allegation is that over about 3 or 4 days, you did a lot of stuff that you weren't supposed to be doing as far as going by or making contact. You actually, they have a video of you going up to the front door on May 27th, which is subsequent to the service of the injunction, which would result in a violation. So the reason they arrested you is not because you called them to ask them to go to the house with you, it's because they already had a warrant for you for violating the injunction.
I understand that now.
Okay.
I've never dealt with anything.
So here's the thing.
Yes, sir.
You're not to have any contact with her.
No, sir.
You're not to go to her address. You're not to go to her work. You're not to have any contact whatsoever. You can return one time now. You can go there one time with law enforcement to get your personal items and get moved out. But you got to call them first and let them know.
Just like I did yesterday.
Yep, exactly. Exactly. But between now and then, don't go to her house.
Oh,
Don't.
no, sir. No,
Yeah,
sir.
right?
I was trying to do everything exactly right. I just,
Well, from what I can read in here, I'm not so certain that that's, you have a different opinion than exactly right, obviously.
well, I was trying to do it the right way. You know what I mean? But I did screw up that one time, yes, sir. Okay, I'm done. I'm
All right, so I'll appoint a public defender to represent you, and if you bond out, you can go there one time, all right? And no return to her place of residence as well as to her place of work, which is the injunction. Follow the injunction, that'll be part of your conditions. No drugs, no weapons, no guns, no alcohol. Okay, all righty. Your name, sir?
Francisco Mano Flackers.
All right. All right, sir, you have two things here today. First of all, you were arrested on a charge of battery domestic violence. And I have read the charging affidavit, and I do find that there is sufficient probable cause. That one here. Do you have another place to go other than 1725 Votah Road? I think that's where your daughter and her grandmother are living, is that right?
Yes, Your Honor.
So do you have another place to go?
Yes, Your Honor.
All right, where's that?
In the woods, anywhere but there.
A friend, is it a relative?
Yeah, I got a few friends.
All right, okay. All right, I'll set bond in the amount of $500. You're to have no contact with your daughter, and that's Lexanie, is that right? Lexanie?
Yes, Your Honor.
And her last name is Castillo also, or Flexer?
Flacker, sir.
Okay, Flacker. And you're also not to have any contact with her grandmother, Herminia Flacker. Okay? No return to 1725 Votar Road. You can go there one time with law enforcement to go get your items. Okay, but that's it. You're not to possess any guns or alcohol, no drugs, no weapons, and you're not, and I'll appoint a public defender to represent you.
Yes, Your Honor.
Okay?
Your Honor, he also has a VOP.
Oh, yeah,
You have to call it.
I forgot. And you're also here for an on-site violation of probation. You were on probation for an ag battery, number of things. I think actually it didn't end up being all of that, but. And so on the violation of probation, there is no bond. And I'll appoint a public defender to represent you on that as well. Your name, ma'am? All right, Ms. Martinez, you're here today because you're arrested on charge of aggravated battery with a deadly weapon.
Sir.
Domestic violence. I have reviewed the charging affidavit and I do find that there's sufficient probable cause. Your name, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Your name?
Marquise Davis.
You might have to get a little closer to the microphone.
Marquise Davis.
All right, sir, you are the alleged victim in the case, is that right?
Yes.
Okay. And tell me what you want me to know.
I don't deem her a threat, and
I'm sorry, you're gonna have to get closer.
I said I don't deem her a threat, and I don't want her. I don't want to press any charges or anything like that.
All right, so you don't have any problem. You guys were living together at the Rio Grande Avenue address?
Yes, sir.
All right, so you have no problem with her returning home there?
No.
Okay. Well, I'll make it no hostile contact, okay? And obviously, picking up a knife and swinging it around is hostile contact, so that can't happen again. All right, so I'll set bond in the amount of $500. And so, ma'am, you're not to have any hostile contact with him. So you can't pick up a knife, can't yell at him, can't scream at him, can't throw anything in his direction. No hostile contact, okay? Understand?
Thank you.
All right. And I'll let you go back to your place. You can go back there because he says he doesn't fear you. And then also, you're not to possess any guns or weapons, and you're not to use or possess any alcohol or drugs. Okay? And I'll appoint a public defender to represent you.
Excuse me, one second. How would
Sorry,
how would the bond thing go? How do I get a bond for her?
It's $500. You can either post a $500 cash bond, and then you'll get the whole thing back when it's over, or you can speak to a bondsman.
Okay.
All righty? Your name, sir?
Deontay Osborne.
All right, Mr. Osborne. You're here today because you were arrested on a charge of aggravated assault, domestic violence, and conspiracy to commit battery. I have reviewed the charging affidavit, and I do find there's sufficient probable cause on the aggravated assault, domestic violence, but I'm not sure where the conspiracy to commit battery comes from.
Your Honor, it sometimes comes in that way. I believe it's just supposed to be a battery.
That's what I thought it was probably supposed to be. So at any rate, all right, ma'am, raise your hand. Right hand. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
And your name is?
Jennifer Osborne?
All right, and you are the alleged victim in the case, is that right? You're the alleged victim?
Yes, sir.
All right. And do you want him to come home or not?
Yes, I do. I came here to do the right thing. I was extremely drunk that night. He did not put his hands on me. I was angry about something that he said. And when I became really belligerent, I wanted the keys. And he was taking the keys to leave
because I was like really out of control. So I called the police. And when I called the police, they were telling me that I had to make a statement. I didn't want to make a statement. I was really drunk. They told me, they asked me if I had any to drink, and I was very honest with them. And they said that they couldn't get my keys from him. The only way that they could was if I made a statement. And so I just said the first thing that came to my mind, and I feel really awful. I'm seeking help for my alcohol problem with AA, but he did not do anything. He was actually just trying to get away from me because I was extremely drunk and was trying to be aggressive. Well, I was being aggressive.
All right, so you don't have any problem with him coming back then?
No, I do not.
Now, let me ask you, there's another, he's out on bond currently on a battery, domestic violence charge.
Correct.
Was that involving you too?
That was involving me, and that's why I'm seeking help for my alcohol problem, because I was extremely intoxicated and made accusations that weren't correct.
Well, even intoxicated people can be victims, you know.
Oh, yes, no, I completely understand.
Your Honor, that case allegedly occurred, the out on bond case,
Yeah,
April 23rd.
yeah.
A no contact was originally put in place. That was just changed. There was a motion to modify that contact order on 5/9, and then we're here for this case. So state's asking for no contact at this time.
Yeah, you know, this is what I'll do. As far as the exile, I'll set bond amount of $500. I'm gonna ROR on the conspiracy to commit if you guys want to amend that, but I'm not gonna, I can't find there's probable cause on that. I'm not gonna let you guys be together for right now. I'm just gonna say no contact. I agree with the state. I mean, the way I can do that is just revoke the bond on the second case, and then it's not an issue.
Well, Your Honor, he is the main caretaker for my children, and
Yeah, but my concern is that regardless of whether it's just your alcohol problem that's provoking something, it appears that within a month, there's been 2 domestic violence incidents in your house. The allegation now is that it has gone from a regular domestic violence to a aggravated assault, that now there's weapons involved.
he did not have.
My fear is the next time I read about your guys' names is gonna be that you're dead on the floor.
I don't fear for my life, Your Honor, and I don't own a weapon. He doesn't own a weapon. Like I said, the officer was like that they couldn't just take my keys from him, that the only way that I could get my keys was to make a statement. And so I said the first thing that came to my mind. I'm here to do the right thing and to be honest with the court, because this is wasting time and money. He is a good person. He is a main caretaker for my children. If, I can't have him home to take care of my children, I'll lose my job, I'll get evicted, my world just goes downhill.
Well, but if you get killed, none of that matters either. If he murders you, because that's where it's headed, right? And so are you telling me that the other case didn't happen too?
It was an argument. Yes, it was an argument, but he didn't break my phone. I actually ran over my phone. I should have brought my son here today. I'm new to the area, so because he was a witness that I actually drove over my phone. My husband did not break my phone. And when I tried to go for him, I stumbled back and fell on the dog cage. That was from the previous case. And I didn't want to move forward with those charges. We got the no contact order lifted, and I started drinking again. My husband was not drinking. He was very sober, and I was extremely intoxicated. I was extremely angry. I have a lot of things to work on myself, and I would hate for him to have to sit in jail off of my actions and off of what I falsely accused of him because I was intoxicated and I wanted my keys.
Your Honor, if I may, on the Out on bond, I would ask that you consider not taking any action. My client is okay for now with the no contact order, being that there is an alcohol issue and this keeps occurring. But he was arrested on the 28th, and to date, the state has not filed any formal charges. And I believe it's probably because the witness or the victim does not want to proceed with charges. So I just ask that you take no action. I believe the no contact order is going to prevent any further altercations from occurring. And if you look, my client just recently started working full-time. I don't want him to lose his job.
Your Honor, state's main concern is he has a fairly significant violent history, as well as 5 prior protection orders. I'm unsure of the victims of those cases, however, just shows a propensity for these same charges.
All right. As to 2022 CF 615AO aggravated assault set bond in the amount of $1,000. What did I set it for already?
5.
Yeah, all right, I'll leave it at that. No contact with Jennifer Osborne. You're not to return to that address. At least on the short term. And as to I'll leave the bond in place on the other case. However, I'm going to change the conditions of release to require no contact on that case as well. I'm going to revert it back to what it was before. So you're not to have any contact with her, and you're not to contact him.
Yes,
Okay? No contact whatsoever. You're not to return to your address with her. And you're not to possess any drugs or alcohol or any guns or weapons. All right, and public defender be appointed on your case.
am I all set to go?
Is that, yeah, you're all set.
Thank you.
Your name, ma'am? All right, ma'am, you're here today because you're arrested on charge of burglary of a dwelling with assault or battery, domestic violence, and criminal mischief. Based on a charging affidavit, an arrest warrant that was signed by a judge.
Your Honor, I know it's an arrest warrant. I don't see any type of assault or battery.
Did have questions about that. I mean, I think it's a burglary of a dwelling, but I'm not sure. He just said that he was afraid, but I didn't see anything in there that indicated that that would show that was a reasonable fear.
And he actually stated that no threats were made as far as photos or, I don't see any threats. So I would just ask that you find PC only for burglary of a dwelling.
Non-criminal judges reading these things, and sure, that looks good. Okay, so I mean, I would find that there's probable cause for burglary of a dwelling, and you don't live at that address. That was some other guy's address, right? So you have no reason to go back there at all. All right. As to I'll find probable cause for burglary of a dwelling, not the assault or battery, so I'll set bond in the amount of $1,500, the criminal mischief $100. I'll appoint a public defender. Now, you're not to return to that address which is 6151 Metro West, Unit 305. You're not to have any contact with hold on a second. Is that the right address? Was that yeah, okay, that was what the disturbance was. No contact with Achraf Lazar, Achraf, last name Lazaar. All right, shouldn't have, there's no reason to have any contact with him, okay? No guns, no weapons, no drugs, no alcohol, upon a public defender to represent you.
And Madam Clerk, the statute for the burg dwelling is 810.02, sub 3, sub B, as in boy.
Thank you. Okay, moving on. Your name, sir?
Cody Alman.
Mr. Alman, you're here today because you were arrested on charge of domestic violence battery. Have read the charging affidavit. We do find sufficient probable cause.
Your Honor, we have a victim approaching.
All righty. I was wondering if there was someone coming. All right. Raise your right hand as best you can. There you go. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Do.
Need to get a little closer to the microphone. Your name?
Courtney Alman.
All right. And you are the alleged victim in the case?
Yes.
Okay. And what did you want to tell me?
I don't want to press any charges against him. I obviously.
So you're okay if he comes home?
Yeah, we have 2 kids. I mean, he's turning 1 tomorrow and stuff like that. I just wanted him to understand that he can't do it to me. So I'm sorry.
It's okay. That's all right. At least I can hear you, so it's no problem. All right, Mr. Alman, if I let you go home, you can't have any hostile contact with her. That means no raising voices, no throwing laundry bins around or anything like that. You understand?
Yes, sir.
All right, so you do qualify for pretrial release. I can let you go on pretrial release, which means you wouldn't have to post a bond, but there are conditions that go along with pretrial release. Got to phone into them from time to time and things such as that. Or I can just set you a bond of $500. You don't have to worry about it, but you do have to post that bond. Which one would you prefer?
The pretrial release would be.
All right, I will release you pretrial with pretrial release conditions. No hostile contact with Courtney Amon, and no guns, no weapons, no drugs, no alcohol. Okay?
Sir.
And I'll appoint a public defender to represent you.
Yes, sir.
Thank you, ma'am. Where'd the baby go? Okay.
Put him down for a second. He's heavy.
Just disappeared. All right, your name, sir? All right, Mr. Burgos, you're here today because you're arrested on a charge of domestic violence battery. I have read the charging affidavit, and I do find that there's sufficient probable cause. In here, okay. Were you living at the 2769 Messina Avenue address?
Yes, sir.
All right, and does Mr. Diaz live at that address?
Yes, sir.
All right, so do you have another place to go other than that address to live?
Yes, sir.
Okay, great.
I just came out of Lakeside.
Okay. All right, I'll set bond amount of $500. You can't return to 2769 Messina Avenue, and you're not to have any contact with Mr. Diaz, Enrique Diaz, okay? No contact with him. No drugs, no alcohol, no guns, no weapons, and I'll appoint a public defender to represent you. And I'll take no action on the petty theft bond.
Thank you.
All right.
Thank you.
All righty, good luck. Your name, ma'am?
Alicia Cobb.
All right, Ms. Cobb, you're here today because you're arrested on a charge of domestic violence battery. The court has reviewed the charging affidavit, and I do find that there is sufficient probable cause. And, raise your right hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Need to step a little closer to the microphone. And your name is?
Edward Green.
All right, Mr. Green, and you are the alleged victim, is that correct?
Yes.
All right, are you here because you would like her to be able to return home?
We don't stay together.
All right, do you guys live together?
No.
You don't, all right. And so the Lawndale Road address, is that your address or her address?
My address.
That's your address. Is there any reason why, so, does she have anything at your house that she'd have to come and get?
No.
All right. And, you are, you want no contact or no hostile contact?
No contact.
No contact. All right, no problem. All right, but there's no reason that she has to go, and I guess the only thing was her keys, and they found those in your truck, and everything has been returned to her, right?
Yes.
Okay. All right, Ms. Cobb, I'll step on the amount of $500. You're not to have any contact with Mr. Green,
Yes, sir, no problem.
okay?
Yes,
And
sir.
you're not to go to his house, not to
No,
go to
you
his
don't have
place
to
of
worry
work?
about it, sir, I promise I won't.
Perfect. No contact whatsoever. No guns, no weapons, no drugs, no alcohol, okay? And so don't go to 5708 Lawndale Road, okay?
Yes, sir.
All righty. Thank you, sir. Your name, sir?
Michael Macon.
All right, Mr. Macon, you're here today because you're arrested on a charge of domestic violence battery. I have read the charging affidavit, and I do find that there is sufficient probable cause. And no one's here, okay. The Orange Center Boulevard address, is that your address?
Yes, sir.
And does Miss Steverson live there?
No, sir.
She does not, so she was visiting you?
She popped up without being told to come.
All right, but I mean, so she has her own place of residence?
Yes, sir.
Okay. And,
We're not even in a relation.
and what about the kids? Are those your kids?
No.
All right, so there's no reason at all that you need to have any contact with her?
No.
Okay. All right, I'll step on the amount of $500. No contact with Ms. Steverson, which is Moesha, Moesha, Michelle Steverson, Steverson. No contact with her whatsoever. That means phone, text, physical contact, nothing at all, okay? And no guns, no weapons, no drugs, no alcohol. I'll appoint a public defender to represent you. Your name, sir?
Ed Scott.
Mr. Scott, you're here today because you're arrested on a charge of domestic violence battery.
Correct, sir.
All right, and I have taken a look at the charging affidavit, and I do find there's sufficient probable cause. You are from Wisconsin, is that right?
Correct.
All right, and where's the rest of the family? Have they gone back, or are they still in town?
My wife is still in town. My mom and sisters, I'm not sure.
Okay. And there's no one here. The 1874 Avenue of the Stars, that's where you were staying, right?
Art of Animation, I'm not sure the address. So.
Yeah, okay. The hotel. All right, I'll step on the amount of $500. You are not to have any contact, and it was your sister, right?
Yes, she lives in Colorado.
Okay. You're not to have any contact with, so is that your brother's? Who is Alia Scott?
That's my wife.
Okay. And so Amy is the alleged victim, is that right?
My sister.
Okay, and her name is Amy?
Amy Scott.
Amy Scott, okay. So, you're to have no contact with Amy Scott, okay?
Okay.
All right. And no guns, no weapons, no drugs, no alcohol. Now, is your plan to go back to Wisconsin?
Yes, sir, we fly out tonight.
Okay, I don't have any objection to that. I'll appoint a public defender to represent you. Make sure you stay in contact with your lawyer, okay, so we know where you are. But if you post a bond, a cash bond with the county, make sure that you have your address there. If you post it through a bondsman, you have to keep in contact with the bondsman.
How do we pay this?
So $500, you can either do a cash bond directly to the county at the jail here, and if you do that, at the end of the case, you get it all back. If you go through a bondsman, they charge, right? They'll charge a premium that won't be returned to you at the end.
I can have my wife.
But you may not have to post the whole 500, although you being from Wisconsin, my guess is Most bondsmen are probably gonna say they want you to post the whole amount, so there's no reason to go through them. You might as well just give the money to the county. They'll hold on to it. At the end of the case, you get it back.
Does my wife bring cash to the courthouse here?
Yeah, they'll tell you downstairs.
Okay.
All right?
Your Honor, this occurred at Epcot, so they would ask for a no return.
Yeah, no return to Disney or Epcot. Probably doesn't. I think he probably got trespassed there anyways, usually.
Most likely.
All right. Another lovely Disney vacation. That's what happens. That's why they don't like alcohol at Disney. Epcot always is the problem. All right, your name, ma'am?
Destiny Perry.
All right, raise your hand, please. Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. And your name?
Angel Smith.
All right, Ms. Smith, you're here today because you're arrested on a charge of domestic violence battery. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. So, Destiny, are you here because you want to have contact or because you don't want to have contact?
Because I do want to have
You
contact.
do want to have contact. So you don't have any fear of her?
Not at all. I feel like this is a misunderstanding.
All right, so I can make it no hostile contact then? And are you guys living together?
We do.
Okay, so the Pierce Avenue address, Hansel Avenue East, Pierce Avenue?
1724 Mercy Drive.
I don't know what, I guess that's because it was outside. All right, so, but you guys can come back together. All right, fine.
Right.
All right, so ma'am, you are eligible for pretrial release, which means that you could be released without a bond, but there are conditions that come with that. Or you can post a bond, I could set it at $500, and then you'd have to pay the $500. But if you want to go to PTR, there are conditions, but you wouldn't have to post any bond.
And what is that? I'm sorry.
Pretrial release,
Mhm.
so you have to call in, and there's some other stuff that you have to do, but.
Your Honor, she would like the $500 bond.
I set bond amount of $500. No hostile contact with Destiny. Just no hostile contact. That means she can't raise her voice, can't scream at you, can't throw something, that kind of thing, all right? But you guys can be together. No guns, no weapons, no drugs, no alcohol, and I'll appoint a public defender. Thank you, ma'am. Your name, sir? Your name?
Mike Vento, sir.
Hi, Mr. Vento, you're here today because you're arrested on a charge of battery domestic violence. I have read the charging affidavit. I do find that there's sufficient probable cause. And were you living at 5619 Ridgeway with Miss Mendieta?
Yes, sir.
And is she still there?
I believe so. I'm not sure.
All right. So do you have another place to go?
I do not.
Friend, relative? Because you can't go back there. She's not here to say that it's okay, so I wouldn't be able to, I can't let you go back there, at least on the short term.
I would have to just, I have a job.
You don't have like any friends, anybody that would let you stay with them?
Yeah, there's a
That's
friend.
sad if that's true. Come on, you gotta have
I'm
somebody.
new in Orlando. We're not from Orlando. We're from Miami, so.
Well, then that might be what you have to do. I mean, I wouldn't have any objection to that as long as you're with your bondsman, okay?
I have a friend named Derek that he could probably help me out.
All right, what I'll do is I'm gonna set bond amount of $500, no return to 5619 Ridgeway Drive. You can go back there one time with the law enforcement to pick up any items you need, clothing, toiletries, that type thing. And then I'm also gonna order that you have no contact with Claudia Mendieta, that's MENDIETA, no contact with her. No drugs, no weapons, no guns, no alcohol, and I'll appoint a public defender to represent you.
Your Honor?
Yep.
A question?
Yep.
The bond, I have it in my property. I have the means to pay for the bond.
I don't know how that works, how? So you have 500 cash in there?
Yeah, on my debit card.
Yeah, okay. All right, well, they'll work with you downstairs.
Thank you, Your Honor.
Okay, good luck. All right, your name, sir?
Logan Clark.
Ms. Clark, you're here today because you're arrested on several out-of-county warrants. Is there any bond on any of those?
No, Your Honor.
They're all no bond, and what county?
Hillsborough?
from Hillsborough County. Hillsborough County will be notified, and hopefully they'll come and get you pretty quickly, okay? Hillsborough County, you have 3 warrants for out of county from Hillsborough. There is no bond, and Hillsborough County will be notified that you're here so they can come and get you, okay?
Thank you.
All righty. 500 on Davis. Are your name, sir?
Cornelius Jawan Davis.
Mr. Davis, you arrested on out-of-county warrants. There is a bond of $500 on those. Is that right? On both?
No, just 500, yeah, 500 on both, so altogether it's 500.
Oh, for a total, okay. And that's from Volusia County, and they'll be notified if you don't bond out, they'll be notified to come and get you, okay?
Oh, okay.
All righty. All right, well, then those bonds are in place. There's no reason to. And then also, no action on the Seminole County bond. So these don't show up on here, right? These ones are not on Odyssey. They are? Where are they? Different division. Oh, okay. Oh, you know what? I think you told me that before. Yeah, there we go. I think you did tell me that before. These are what? 4? Count on you guys to give me the info. Are your name, ma'am?
Christina Kenworthy.
All right, ma'am, you're here on a warrant, an out-of-county warrant from
Seminole?
Yes.
Yes, ma'am. From Seminole County.
Yes, sir.
All righty, and there is no bond on that, and we will contact Seminole County to let them know that you're here.
They'll come get me, sir?
Yeah, yep.
Thank you.
We'll let them know. Your name, sir?
Joshua Oathout.
All right, sir, you're here today on a warrant out of Lee County,
Yeah.
and there is no bond on that, and Lee County will be notified. Your name, sir?
Santoro,
First name, John?
first name John.
All right, sir, you're here on a warrant out of Osceola County. The bond is set at $1,000. And either you make the bond or we'll contact Osceola and they'll come and get you, okay? Your name?
Juanita Wells.
Ms. Wells, you're here for a warrant from Osceola County. And there's 2 counts. One is a $1,500 bond and the other count is a $500 bond. So if you make those bonds, then you'll have to report to Osceola County. If not, we'll let them know and they'll come and get you.
Okay.
All righty? I'm gonna go back. Okay, Bryant. All right, Mr. Bryant is charged with violation of probation. There is no bonds. Is it? Hang on. Oh, yeah, $2,500. Appoint a public defender to represent him on the violation. Your name, sir?
Gregory Butner.
Just a sec. You're here because you're arrested on a violation of probation. On your attempted burglary. There's on count 1 and 2, there's $1,000 bonds on each, so it's a total of $2,000. Appoint a public defender to represent you on the violation of probation. Your name, sir? Your name?
Darius Burgess, sir.
Mr. Burgess, you're here today because you're arrested on a charge of possession of cannabis less than 20 grams. I have reviewed the charging affidavit, and I do find sufficient probable cause. I'll set bond the amount of $100 on that. And then you also had, under Burgress. Hang on. That one was under Burgress. The Burgess one is a, violation of probation. Is this the one? No.
Your Honor.
No, it's not, yeah.
Being that the violation of probation is a nonviolent crime, and the alleged crime against me is a nonviolent crime, could bail be set for the violation of probation? I have no victim in that case, and it's a nonviolent crime, sir.
I mean, to me, that doesn't really matter, but the question is, are they gonna file on the possession of cannabis?
Potentially, Your Honor. Since it is coming in with a VOP, I'm not at liberty to
Right.
no process today. However, since it is attached to the VOP, it'll most likely be
All right,
looked at
what
quickly.
I'll do is I'll set bond on the violation of probation at $2,500. It is just a possession of a firearm. Okay? No guns, no weapons, no drugs, no alcohol. None, okay? Point of public defender. What was that on Johnson? I'm sorry.
Behavior.
Johnson. I will waive the appearance, Your Honor.
Johnson's violation of probation. And there is no bond, point of public defender. Your name, sir?
Tyler Lettieri.
Mr. Lettieri, you're here on a violation of probation for the fleeing, attempting to elude. There is no bond. I'll appoint a public defender to represent you.
I had a question.
Sure.
I wasn't driving.
Stop.
That fleeing, attempting to elude is what you were on probation for. This new case, I don't know, it's an onsite. So that's not, if you're talking about your original case, that's all water under the bridge. They say that you got a new driving license suspended and also didn't complete the advanced driver improvement school as required by the judge. So those are the two reasons for the violation. So I'll appoint a public defender to represent you. Okay, your name, sir?
Lewis.
So, okay, here, Mr. Lewis, you're here for a violation of probation. And there is no bond on that. So correct me if I'm wrong here. And then they've got the possession of cannabis that he's out on bond for that they want me to take action on. But I think that the possession of cannabis that he's out on bond on is what caused the violation. Am I wrong about that? 'Cause it doesn't say for sure, but I'm going to assume.
One second.
He was on probation for
Fleeing and eluding?
the fleeing.
Yes, Your Honor, fleeing and
Okay.
eluding.
And then he got a new possession of cannabis, that 2022 CF 3979 AO. And that was he was bonded out on 425. But I don't know what the new, couldn't figure out what caused him to be violated on this.
I believe it was, Your Honor.
Yeah, it seemed like it's sort of like the dog is chasing its tail there.
It says.
Now, I mean, as far as the violation goes, we can discuss that, but I'm not gonna, the reason I'm saying that is it's all a long way of saying, I don't think I should take action on the other case because, where he's out on bond because he didn't, he got arrested for something, but didn't violate that bond. And it's the reason he's getting arrested is because of that same case, right?
Yes, Your Honor, I believe so. It says, because of
It
his
does
arrest.
say 22-33790, which is,
I think that's the.
yeah, well, it's not, but.
It's different.
The number's way too high to be a real number. That's not a case number. It's way too high.
I believe he may have wrote the wrong case number, Your Honor, the officer.
All right, well, here's what I'll do. The violation of probation,
You see it?
Oh, it's an agency case number, not a court case number.
I mean, it clearly is a violation, so, there's no bond on that, but I will appoint a public defender on that, and I'll take no action on the possession of cannabis. Done. Talking, a whole lot of talking for nothing. Okay, your name, sir?
Michael Javier Rivera Mercado.
We got several things here. Let's see, 3 cases. 2019 CF 15058 AO, which is a violation of probation. There is no bond. 2020 CF 13261 AO, violation of probation, community control, no bond. And 2019 CF 15067 AO, violation of community control or probation, no bond. I'll appoint a public defender to represent you on all of those. Your name?
Ariana Wood.
All right, ma'am, you're here on a violation of probation charge. And, how did that happen? This is based on your trespass. Failed to report. All right, there is no bond on that. Where did Wayne Wooten end up with that? I'll appoint a public defender to represent you. Man, that was some weird stuff today. All right. 33 days. Case number 2022 CF 4810 AO, Aubrey Brown.
Granted, notice and on filing.
Today, the 1st of June. Uh, 2022 CF 4718 AO, Michael Burnett.
Granted, notice and on filing.
MM 2881 AO, Michael Hendricks.
Denied, and information was filed.
(2022) CF 4799 AO.
Mr. Jackson, granted, notice and on filing.
Yeah, Arthur Jackson, sorry. 2022 CF 4854 AO, Devontae Jones.
Denied, and information was filed.
(2022) CF 4857 AO, Robert Lewis Jr.
Granted, notice and on filing.
2022 CF 4821 AO, Norris Palmer II.
Granted, notice and on filing.
2022 CF 4719 AO, Marcus Patterson.
Denied, and information was filed.
(2022) CF 4859 AO, Joshua Pfeiffer.
Granted, notice and on filing.
2021 CF 15855 AO,
Granted, notice and on filing.
That's Modesto Ruiz. And last 2022 CF 4867 AO Tarvis Lorraine Williamson.
Granted, notice and on filing.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good afternoon, sir.
Buenas tardes, caballero. Good afternoon.
Sir, you were arrested for the charge of misdemeanor battery, domestic violence.
Usted fue arrestado, caballero, por el delito menor de cargo de agresión relacionado a la violencia doméstica.
There is probable cause based on the affidavit.
¿Existe motivo fundado basado en el affidavit?
We have a witness here for this case.
Tenemos un testigo aquí para este caso.
All right, we don't have a witness here for this case.
No tenemos testigo.
Sir, I've reviewed the affidavit and note that the alleged victim is your daughter.
Al haber revisado el informe, veo que la presunta víctima es su hija.
How old are your children?
¿Qué edad tienen sus niños? She's 20 years old. She's 19.
All right. And how about the other daughter, Alicia? How old is she?
¿Y su otra hija, Alicia, qué edad tiene? 21.
Y tengo otras también, Allison de 26, Christian de 12 y Carlos de 16.
And I have other ones, Allison 26, Christian 12, and Carlos 16.
All right. Is there another adult in the home other than, in other words, do you have a spouse who lives in the residence as well?
¿Hay otro adulto que vive en la casa? O sea, ¿usted tiene una esposa que vive en la casa también?
Sí.
Yes.
Do you have relatives in town whom you can reside with while your case is pending?
¿Usted tiene familiares aquí en la ciudad que usted pueda vivir mientras esté pendiente este caso?
No.
No.
If I require that you reside somewhere other than 155 Magic Landings Boulevard, where would you be staying?
Señor, si yo le exijo a usted que no puede vivir en 155 Magic Landings Boulevard, ¿dónde se quedaría usted?
No tengo idea, pero buscaría, ¿no?
I have no idea, but I guess I'd look for one, right?
All right. Yes, sir, because of the nature of the arrest and because I don't have anyone here to testify about your return to the residence, I'm going to set your bond at a relatively low amount.
Debido a la naturaleza de su arresto y debido a que no hay nadie aquí presente que testigue sobre los acontecimientos y sobre las condiciones de su regreso al hogar, le voy a programar una fianza reducida.
And I'm going to do that with pretrial release conditions.
Lo voy a establecer con condiciones de libertad provisional.
And the reason I'm setting a lower bond is so that it does not affect you financially as harshly so that you'll be able to find another place to stay.
Y la manera por la cual estoy reduciendo una fianza, y será una fianza relativamente menor, es para que usted tenga la oportunidad de conseguir un lugar donde quedarse y esto no le afecte de manera financiera.
All right, so bond will be set at $500 with pretrial release conditions.
La fianza será programada en $500 con condiciones de libertad provisional.
Conditions of bond are no contact with the alleged victim or witnesses.
Con condiciones en su libertad que no se le permitirá trato con la presunta víctima o los testigos.
Must maintain a separate residence.
Tiene que mantener una residencia separada.
You may not return to the location of the alleged offense.
No puede regresar al lugar de los acontecimientos.
There will be one exception, and that exception is you may return with law enforcement one time to obtain personal belongings.
Se le permitirá regresar una sola vez acompañado de un agente del orden público para recopilar sus pertenencias personales.
You may not possess any weapons or firearms while you are on release in this case.
No se le permitirá portar armas de fuego o armas blancas mientras que usted permanezca en libertad provisional.
Do you have any questions, sir?
¿Tiene usted alguna pregunta, caballero?
No.
No.
Thank you, sir.
Gracias, caballero.
So our next case would be Antonio Franco Acevedo, 2022 MM1226.
Thank you, Your Honor.
Good afternoon, sir.
Buenas tardes, caballero.
Sir, you've been arrested for misdemeanor battery, domestic violence.
Señor, usted ha sido arrestado por un delito menor de un cargo de agresión relacionado a violencia doméstica.
There is probable cause.
¿Existen indicios razonables?
We do not have a witness here for this case today.
No se encuentra un testigo aquí en el día de hoy para este caso.
I'm going to set your bond at a relatively low amount so that you will be able to have more resources for finding another place to stay.
Le voy a programar una fianza reducida para que usted tenga mayores recursos financieros para conseguir un lugar donde quedarse.
So I'm going to set your bond at $500.
Voy a programarle su fianza en $500.
You do not qualify for pretrial release.
Usted no reúne requisitos para el programa de libertad provisional.
So there will be no pretrial release conditions.
No existirán condiciones de libertad provisional.
You may not have any contact with the alleged victim.
No se le permitirá trato con la presunta víctima.
With one exception.
Con una sola excepción.
Actually, two exceptions.
O sea, dos excepciones.
First, you may have non-hostile contact through third parties with regard to parental responsibilities.
Primero que todo, se le permitirá trato sin hostilidad mediante una tercera parte referente a asuntos de crianza de menores.
You may return one time with law enforcement to obtain your personal belongings.
Y se le permitirá regresar una sola vez acompañado de un agente del orden público para recopilar sus pertenencias personales.
Otherwise, you may not return to 712 Missouri Avenue in St. Cloud.
De otros modos, no se le permitirá regresar al 712 Missouri Avenue en el pueblo de St. Cloud.
You must maintain a separate residence.
Tiene que mantener una residencia separada.
You must not possess any weapons or firearms while you are on release in this case.
No se le permitirá portar armas de fuego o armas blancas mientras usted esté en libertad en este caso.
And as I said, no contact with the alleged victim except through third parties for child visitation and custody arrangements.
Y como le dije, se le prohíbe trato con la víctima a que no sea la excepción de trato sin hostilidad mediante una tercera parte para tramitar los asuntos de visitas y de los niños.
Do you have any questions, sir?
¿Tiene usted alguna pregunta, caballero? No, su señoría.
All right, thank you.
Gracias.
Mr. Interpreter, could you ask one more time if anyone else needs your assistance?
We do have one more, Your Honor.
Oh, who is that, Ms. Clark?
Angel Rodriguez.
Angel Rodriguez, okay. This is Miami-Dade case number 5894B.
Thank you, Your Honor.
Good afternoon, sir.
Buenas tardes, caballero. Good afternoon.
Sir, you were arrested on a violation of probation warrant from the 11th Judicial Circuit.
Señor, usted fue arrestado por una orden de arresto que fue emitida por incumplimiento de libertad en el 11º Distrito Judicial.
There is no bond.
No tiene derecho a fianza en este momento.
You will be transported back to Miami-Dade County, where you can address the issue of bond with the presiding judge.
Usted será transportado al condado de Miami-Dade, donde usted puede tramitar los detalles de la fianza con el juez del caso.
I have provisionally appointed the Public Defender's Office here. If there are any issues, they can assist you here.
Le estoy designando las oficinas del defensor público de manera provisional para que lo ayuden si se presenta algún asunto mientras que usted esté aquí.
Thank you, sir.
Gracias, caballero. Your Honor, would you like the interpreter to make an announcement?
Please.
Su atención, por favor, si hay alguna persona presente que necesite los servicios del intérprete, por favor, alce la mano en este momento.
I see no hands, Your Honor.
All right, thank you, Ms. Clark. Thank you, Mr. Interpreter.
You're welcome, Your Honor. Have a good afternoon.
You as well. All right, the next case will be Zachary Jesus Lopez, 2021 CF 577. Good afternoon, sir. You were arrested on a violation of probation warrant out of Division 12, Judge Karsten. You're alleged to have violated conditions 9 and 13 of the order of probation. Judge Karsten signed the warrant and set zero bond. Do we have a next court date for Mr. Lopez?
June 15th at 9 a.m.
All right, so you'll have a VOP status on June 15th at 9 a.m.
Thank you.
Okay, thank you. Next case, Anthony Elias Santiago, 2021 CF 166.
Good afternoon, sir.
Good afternoon. So you were arrested for a violation of probation. The charges are that you violated conditions 5, 9, and 13 of the order of probation. Judge Carson issued the warrant and set zero bond. Madam Clerk, do we have a court date for Mr. Santiago?
June 15th.
All right, June 15th at 9 a.m. will be your next court date before Judge Karsten, sir. Thank you.
Thank you, Your Honor.
Michael Ballou, 2022 MM1224.
He refused, Your Honor.
All right, we'll set Mr. Ballou for tomorrow. Angela Beloyanis, I apologize if I mispronounce that, 2022 CF 1550. Ma'am, how do you pronounce your last name?
Beloyanis.
Beloyanis, okay. You were arrested for petty theft, third or subsequent offense. There is probable cause. Your bond in the case is set at $1,000 with the condition that you will not return to the 7-Eleven at 7411 West 192 in Kissimmee. May not have any contact with witnesses. Your bond in the other cases pending is going to be revoked because of the new charge. So the bonds in 2022 MM 1136 and 2022 CF 1353 will be revoked and pretrial detention will be ordered in those cases. All right, I don't believe I need to do anything further. Ms. Clark, is there anything else I need to address here?
No, Your Honor, I don't see anything.
Okay, Ms. Klein-Peter for the state.
Nothing to say, Your Honor.
All right, thank you, ma'am. Dwayne Forrest, 2022 MM 1225.
I have a brief PC argument in this case, Your Honor.
All right, we have witnesses here also, and I believe the other party is also in custody. So, Mr. Forrest, you were arrested for misdemeanor battery, domestic violence. And Ms. Clark, your argument?
Yes, Your Honor, in reviewing the affidavit, I do not see anywhere where he was the aggressor. In all the paragraphs, all the witnesses, and the videotape reviewed by the police officers, it shows that when he went to reach for the controller, he was then assaulted. So it seems that everything after that seemed to be him doing self-defense. At the very end, I do see where the police officer says they were unable to determine the primary aggressor, but in reviewing all the tapes and all the statements, like I said, right after he reaches for the controller, he was assaulted. And then after that, it seems that he defended himself.
There is a note in here that he charged at the other party and grabbed her by the throat.
Yes, and then in reviewing the video, the police officer says that he did not see that. He made it a point to say that he did not see, in reviewing the video, him grab the other individual by the throat.
Let me look at that again.
In the last paragraph, it says it did not appear in the video that Dwayne placed his hands on Abiola's neck. That's the police officer's statement from the video.
Rushing her and pushing her against the wall for a moment. Did not appear in the video that he placed his hands on her neck. Okay. Pushes her back onto the secondary bed. All right, Ms. Klein-Peter, do you wish to be heard?
Yes, Your Honor. It indicates here that the girlfriend hid the controller underneath the bed. That's in the description of the video. They were arguing over the controller. At that point, he pushes her off the bed. At that point, it's battery. Pushing her off the bed is PC for battery at that point. And we're not arguing for, the grabbing on the neck would be an argument towards bat strangulation. We're not arguing for that. We're arguing for simple misdemeanor domestic battery.
All right, Ms. Clark?
Yes, Your Honor. The only statement that says that after he reached for the controller, he reached for the controller, then he pushed her off the bed is her statement. There are various lies in that statement by omission or commission where she failed to say that she bit him. She failed to say how she prevented him from grabbing the controller. And every other statement, his and the videos, it says that she assaulted him after he attempted to grab the controller. And then he pushed her in self-defense. That's what the video shows, both videos, and that's what his statement is.
All right. I think there is sufficient probable cause. I mean, it's a mutual situation, and I think it's clear that both parties perhaps may be in a toxic relationship, and perhaps they need to find some more constructive things to do with their lives than PlayStation. but there is probable cause for this purpose. So Mr. Forrest's parents are here, and I'd like to hear from them with regard to terms of release. So you want to step on up to the lectern. We're being recorded by a digital court reporter, so you can't see a court reporter, but we are being recorded, so please speak up. If you'll raise your right hand to be sworn, you swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, thank you. So tell me your name and please spell it for the court reporter.
Maxine Forrest, Maxine Forrest.
Okay, thank you, Ms. Forrest. Tell me what you would like for me to consider with regard to terms of release for your son.
Sir, he will be coming back home with us. He is in school, so he doesn't sit on all the time playing games. He's in his third year of college, so that's
CF?
FAU.
Oh, FIU, okay.
Yes, but he does online. He's not a violent person. He obeys the law. He doesn't go over the speed limit. So we just want to take him home.
All right. Well, thank you very much. I'm familiar with the circumstances, so they're a little bit unique. So do you want to say anything?
Oh, yeah.
Okay, so raise your right hand as well, please. You swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Yes. All right. Tell me your name and please spell it.
Donald Forrest, Donald Forrest.
Okay, Mr. Forrest, what would you like to say?
Coolest kid. Don't give trouble. Try to help everybody as possible. As my wife said, even the speed limit, you obey. When I break the speed limit, even the speed limit, you obey. And between him and Abigail, I like Abby. I love Abby. And I'm going home. If I get a chance right now to take them back to Fort Lauderdale, I will take the both of them to Fort Lauderdale right now. And I don't want to leave Dwayne up here right now. I want to take both of them back. I want to take Abby back to her mother and take Dwayne back to my house. You know what I'm saying? And just call it, and letting everything just go back to where it was. You know what I'm saying? Dwayne stay east and Abby stay west. And just, you know what I'm saying? That's what I want. That's what I want right now.
Okay.
I want no charge pressed against nobody. I just want everything to be over right now.
All right.
If it's possible.
Thank you. Ms. Clark, do you have any questions for Ms. Forrest or Mr. Forrest?
I just wanted, it was a little bit hard for us to hear. I just wanted to know if he was going to be able to come home with them and reside with them.
That's what Ms. Forrest testified about. Yes.
Okay. All right. Thank you, Your Honor. That'd be all.
Okay. Ms. Peter, do you have any questions for Mr. or Ms. Forrest?
No questions from the state, Your Honor.
All right. Thank you. All right. So I did find probable cause. I will, under the circumstances, grant ROR. So that means I'm granting release on his own recognizance. There won't be a monetary bond. All right. A condition of the ROR will be that Mr. Forrest reside with his parents and have no contact with the alleged victim and maintain a separate residence from the alleged victim. All right. And I don't believe weapons or firearms was an issue, but in this type of case, we always say no possession of weapons or firearms. So those will be the conditions of the ROR.
Thank you so much.
Okay, thank you.
Thank you.
All right, thank you, Mr. Forrest.
Thank you, Your Honor.
All right, then the next case is Iola Hebert, 2022 MM1227. Okay. Ms. Clark, do you wish to make any type of probable cause argument on this case?
In this case, Your Honor, I would just say that the defendant may have mistaken him reaching behind the pillow for an aggressive act in which she may have decided to then defend herself. She also is low risk and would be asking that if she could be ROR'd also with no contact with the victim also.
Right, so Ms. Hibbert, do you pronounce your name Hibbert or Hebert? Hibbert, okay. Ms. Hibbert, you were arrested for misdemeanor battery, domestic violence. There is probable cause in the affidavit, I believe, for the misdemeanor charge. It is I mean, my comments with regard to Mr. Forrest apply equally to you, but it is a unique circumstance. So I'm going to grant non-monetary release terms for you also. So I will grant release on your own recognizance with the conditions of no contact with Mr. Forrest, maintain a separate residence. If I remember correctly, he had moved into your place, so I'm not going to restrict where you live other than it can't be with Mr. Forrest. You may not possess any weapons or firearms while you're on release in this case. All right. And Madam Clerk, going back to Mr. Forrest's case, he can return one time with law enforcement to obtain any personal belongings from the apartment. All right, Ms. Clark, anything further for Ms. Hibbert?
No, Your Honor.
All right, Ms. Klein-Peter?
Nothing from the state, Your Honor.
Okay, thank you, Ms. Hibbert. All right, the next case, there are two cases. And Ms. Klein-Peter, I need you to look at 2018 CF 223 because I think that case is closed.
State is already with you, Your Honor.
All right, excellent. So this is Alexandra Ritchie, 2022 CT 1734 and 2018 CF 223. All right, good afternoon, ma'am. Good afternoon. Ms. Klein-Peter, do you agree that the sentence has been served in 2018 CF 223?
Yes, Your Honor. State looked at the revoke and termination order from Judge Nix Walker that was filed, as well as I emailed DOC Correctional Officer Melissa Perella. She's our new liaison, and she stated that probation in 18 CF 223 was revoked and terminated on 3/11/2021. That the deputy wrongly on-viewed her, so that should be dismissed and closed out.
Correct.
However, just for your Honor's information and for her information, she is on probation, community control, in 3 cases in Volusia County where a violation has been filed. So just to give her full view of what the picture is, Volusia may be picking her up, or she may be here tomorrow with a VOP from Volusia.
Okay. So, Ms. Ritchie, you were arrested in 2022 CT 1734 for driving while license suspended or revoked. And there is probable cause for that charge. Your bond is going to be set at $500. You were also arrested for a violation of probation allegation in 2018 CF 223. You are not on probation in that case, so that there is no probable cause for that arrest, and that alleged violation will be dismissed because you have served that sentence. All right. According to Ms. Klein-Peter, you are on probation in the 7th Circuit, which is Volusia, or the 7th Circuit includes Volusia. I'm not aware of those cases, so I can't take any action on that, but apparently the Department of Corrections may have already filed something there. So Ms. Klein-Peter wanted you to know that you may be picked up and transported to Volusia. Ms. Clark, is there anything further we need to address for Ms. Ritchie?
No, Your Honor.
Ms. Ritchie, do you have any questions, ma'am?
Yeah, I didn't understand what you meant on the last part. I could be picked up. What do you mean?
Well, I don't have personal knowledge, but the state attorney here in the courtroom advises that you're on probation in Volusia County, in multiple cases.
Okay.
And so probation, apparently, I'm told by the state attorney, has filed notices of violation and submitted warrants to the judge in Volusia. So if the judge signs those warrants, you may be picked up here and taken to Volusia, or if you bond out, you could be rearrested and taken to Volusia.
But as of right now, I can bond out of the jail.
As of right now, you have a bond. I'm not aware of whether there's a hold. There could be a hold that I'm not aware of.
Okay.
Okay?
All right, thank you.
Yes, ma'am. All right, the last case would be Jimmy Watts, 2022 CF 1556. All right, good afternoon, Mr. Watts.
Good afternoon.
Sir, you were arrested for the alleged crimes of attempted felony murder, possession of a firearm by a convicted felon, and obstructing an officer without violence. I've reviewed the affidavit, and there is probable cause in the case. Ms. Kleinpeter, I have a question for the state. I believe the crime attempted was a life felony, which I believe makes the attempt a second-degree felony. Do you agree?
I do, Your Honor, and for your information, state filed with the clerk as she walked in today a motion for pretrial detention,
Okay.
because that was probably where you were going. We have filed a motion for pretrial detention.
Well, he's entitled to a bond, but you have filed a motion for pretrial
We
detention.
have, it is with Madam Clerk.
All right. And Madam Clerk, may I see that, please? So this is in Judge Karsten's division?
Yes.
And are you filing the pretrial detention only on the first ground, I assume?
Yes, Your Honor.
Yes. All right, so I need to set bonds on 2 and 3. Let me look at the statute real quick. All right, so Judge Karsten is out. Judge Nix Walker is on leave. And I am here only this week. There is probable cause, and so we need to set the pretrial detention hearing. Um, So I'm going to set the pretrial detention hearing for tomorrow morning at 9 a.m. in front of Chief Judge Munyon, who will be covering Judge Nix Walker's division, and who can cover for Judge Karsten. If Chief Judge Munyon is unable to hear this case tomorrow morning, I would be able to hear the pretrial detention motion on Friday.
Who's the judge? Minion?
Munyon, M-U-N-Y-O-N.
To be heard to at 9 a.m. before Chief Judge Munyon, standing for Nix Walker.
Judge Munyon would be covering for Judge Karsten, but she's going to be here because she's covering for Judge.
Or June 3rd before Judge Young. I assume you're 9 a.m. covering for Judge Karsten.
Yes. All right. And I need to set bond on the second and third counts. So count 2 will be $10,000, and count 3 will be stayed at $500.
What was the second bond? 4,000?
10,000.
10,000.
I increased it to 10,000.
And just to make sure I understand, Your Honor, although he is entitled to a bond on the second-degree felony, the attempted felony murder, the state filed a motion, and that motion is going to be heard either tomorrow morning, and then if not possible, then Friday morning?
Correct.
Okay.
Correct. He is entitled to a bond unless the pretrial detention is granted, and they have filed a motion. So that's why the court is not setting a bond on count 1 at this time.
Thank you, Your Honor.
Okay, thank you. Anything else, Ms. Clark?
No, Your Honor, that's it. Thank you. Have a good
Thank
day.
you. Ms. Kleinpeter, anything else before we recess?
Nothing from the state, Your Honor.
All right, thank you all. We'll be in recess.
2:30, Your Honor.
Back on the record in Mr. Watt's case, Ms. Clark, I apologize. Pretrial release was asking about conditions. So on the conditions of bond, no contact with any victims or witnesses, no return to the location of the alleged offense, and no possession of any weapons or firearms, which of course would be a new law offense anyway. But those will be the conditions on the 2 bonds that have been set.
Yes, he would like to.
So I only have one thing about it. My phone is in the police hands right now, and I have all my family contact and my job contact, and I can't get in contact with nobody that's an emergency to my family to let them know that's going on. But I did have some type of resources already to try to help me out with certain things. But I do have more family that I would love to get in contact with, because I don't know their numbers by heart or anything. So if I could be able to try to work something out with that situation, and also for my job, because I work at Applebee's, and I would love to let them know what's going on as well.
Yeah, Mr. Watts, I've provisionally appointed the Public Defender's Office to represent you. And so you would need to work with the Public Defender to attempt to get access to any information from your phone or to reach out to family on your behalf. They may be able to help you research those numbers or whatnot.
Yes, sir. No problem.
Okay, thank you.
Thank you, Your Honor.
Yes, ma'am. All right, we're in recess again.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
All right, you guys ready?
Yes, Judge.
Yes, sure.
Okie dokie. Let's do it.
July. Oh, what? Over here. Okay.
Regarding Frankie
Quiz. Okay.
You say Borges?
I signed them all. Thank you.
He's refusing to be fingerprinted.
Yep. Yep. Yep.
I will waive and enter plea of not guilty, Your Honor.
On who?
Grim, is it Grim Kenneth?
He had a written plea of not guilty.
Okay.
All right. So he's got an attorney, okay? All right. You want to, you guys aren't in the case yet, appoint a public defender, set that, Okay, set it for pretrial.
Division 82, July 26th at 9 o'clock in courtroom 9B.
All right.
10 p.m. Also
Set for pretrial.
Division 63, July 7th at 1 o'clock in courtroom 10B.
Devontae McCray. All righty. Your name, sir? Mr. McCray, you're here for pretrial, or excuse me, for arraignment on your petty theft charge. In that case, the state alleges that you did, let's see if I can get the date. You know, okay, where do I find these guys? McCray, I don't see him. Oh, just pull it up, okay. All right, in this case, Mr. McCray, the defendant alleges that you did on or about the 20th day of November of 2021 in Orange County, Florida, in violation of Florida Statute 812.0143B, knowingly obtained or used or endeavored to obtain or use the property of Choice Meats with the intent to temporarily or permanently deprive them of the rights of the property, to benefit from the property, or to appropriate that property to your use. So it's a petty theft charge. They also allege that you had previously been convicted of theft in Orange County, Florida on the 11th of July of 2019, which would make this a first-degree misdemeanor petty theft with a prior theft conviction. State have an offer in the case, or?
Not at this time, Your Honor.
All right. Letter plea not guilty for you. We'll set that for pretrial. And did you want to have a public defender appointed to represent you? Excuse me?
Doesn't matter.
All right, I'll appoint a public defender to represent you.
It'll be pretrial, Division 62, July 28th at 8:30 in courtroom 12C. You go.
Your name, sir?
Junior Henry, sir.
Mr. Henry, you're here today because you were arrested for the charge of loitering and prowling. However, the charging affidavit, do you find there's sufficient probable cause?
Your Honor, state does not have an offer at this time, as I believe there's other charges that may be filed.
Based on the same thing? All right, I'll set bond in the amount of $100. Appoint a public defender to represent you. And,
Your Honor, state would ask for a no return to the Kia car dealership.
all right, no return to the Kia auto dealership where this allegedly occurred. And I revoke the bond on the Osceola case, no bond. Theft case. Your name, ma'am?
Linda Lee Oletti.
Ms. Oletti, you're here today because you were arrested on a charge of, grab it real quick,
Resisting an officer without violence, meaning I was compliant.
and trespass after warning. I have reviewed the charging affidavit and I
Trespass on property after warning.
got that.
There was no warning given. It was a trespass
All
on
right,
the same
ma'am,
day.
just
There
let
was
me
no
finish
another.
talking. Let me finish, okay? You're here on those two charges. I reviewed the charging affidavit. I do find that there's sufficient probable cause. Bond will be set as to the resisting. I'll reduce that bond to $500 and reduce the trespassing bond to $500, and I'll appoint a public defender to represent you.
Okay, I am also a citizen of the Cherokee Nation, which is a different jurisdiction altogether and falls under
No,
different
it's
rules.
not when you're off the reservation. It's not.
No, that's not true. I'm a registered citizen. I have a number. Okay.
Your Honor, George Maxwell refused.
Ms. Maxwell.
We reset for tomorrow, Your Honor. There is an offer to resolve.
All right, I'll reset it for tomorrow. Your name, ma'am?
Lucretia Isaac.
All right, ma'am, you're here today because you were arrested on 4 charges. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. As to the manslaughter by culpable negligence, there's no bond on that. Actually, yeah.
Your Honor, I do believe she's entitled to a bond, but given the allegations within the affidavit, the severity of the charge, and that a death did result, and that a child was involved, state's asking for $50,000 at this time.
I will do that. $50,000 bond as to count 1. Stay the rest of the bonds, $1,500 aggravated assault with a firearm, $150 for the negligent storage, and $150 for the neglect of a child. And I will, if you do bond out, then you're not to possess any firearms.
Your Honor, state's also asking for no contact with victims or witnesses.
No contact with any of the victims or witness. Well, the one witness is, the victim is deceased, but the other witnesses, which would be Marcial Tirado, Monique Ashley, and Kenya Griffin.
Your Honor, state's also requesting no contact with the child at this time.
Is the child with DCF, or do we know what happens? Is there a plan in place?
I'm not sure, Your Honor.
All right, if the child, if DCF has a child, you have to abide by any DCF plan, okay? All right. And again, appoint a public defender to represent you. Your name, ma'am? Your name?
Danielle Lenoci.
All right, Ms. Lenoci, you're here today because you're arrested on an arrest warrant for 1 count of possession of MDMA. Is it 1 or 2? Did they file on? Looks like they only filed 1.
It's one.
Is that?
1.
Yeah, bond is set in the amount of $1,000. I'll appoint a public defender to represent you.
What is it?
Behavior.
All right. Is that when you have a?
Is John Doe Davis?
Oh, yeah. Is that what it is? Let me see. Was he John Doe before? Because, yeah, I don't have Tyrone Davis.
Is it case?
Yeah, that's him.
22?
Disorderly intox. Yep, that's him.
Okay.
All right, as to the charges set bond on the, disorderly intox, $150 and resisting $500, point of public defender. Your name, sir?
My name is Blake Ryan Doble.
All right, sir, you're here today because you were arrested on a charge of trespass on property after warning. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. Set bond amount of $250.
Your Honor, state did convey an offer to Mr. Noble of an adjudication of guilt, credit time served, and no return.
Okay.
And he would like to accept and enter a plea of no contest, Your Honor.
Mr. Doble, so you wish to enter a plea of no contest into the charge of trespass after warning, is that correct?
Yes.
All right, are you under the influence of any drugs or alcohol today? Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes.
You're taking medication for that now?
Now.
And you do understand what's going on here today?
Yes.
All right, you understand that by entering this plea, you give up the rights of that on the plea form? Any questions about those rights?
No, sir.
All right, you understand finally, that this is punishable by up to a year in the county jail, up to $1,000 fine, and the entry of your plea would result in deportation if you're not a citizen. You understand all that?
No. Yes, sir.
All right, I will judge you guilty. You'll be sentenced to the time that you've served in the Orange County Jail. I'll impose court costs and a $50 cost of prosecution. That's a total of $273, and I'll give you 2 years, 24 months to get that paid. Now, also, finally, I'm going to order that you not return to 8990 Turkey Lake Road for a period of 1 year. If you do go back there and the court's made aware of the fact that you've gone back there, you are subject to a contempt citation, which could result into up to 180 days in the Orange County Jail sentence. All right? You'll be released as to this case.
Thank you, Judge.
Okay, take care. Your name, sir?
Calling you.
Mr. Gordon, you're here today because you were arrested on 2 charges. One being resisting an officer without violence, and the second, possession of cannabis, less than 20 grams. I have reviewed the charging affidavit in that. I do find that there is sufficient probable cause, and we'll set bonds.
Your Honor, there is an offer.
Okay, what is that?
The cannabis? Okay. The offer to the resisting, an officer without violence, Your Honor, is an adjudication of guilt, credit, time served, and court costs. And I believe the state has an announcement as to the possession of cannabis.
If Mr. Gordon pleads to the resisting.
I want to get the plea first. So if you want to enter a plea, Mr. Gordon, to the first case, it'd be time served on the resisting, and then they would null process or drop the possession of cannabis, and it would be court costs. Is that what you want to do? All right, so you're going to enter a plea of no contest. Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
Yes, sir.
Taken medication for that today?
No, sir.
Do you understand what's happening here?
Yes, sir.
Understood all the rights in the form? And do you have any questions about the rights on this form?
No, sir.
You understand this is punishable by up to a year in the county jail, up to $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen?
Yes, sir.
All right, I do find sufficient factual basis to accept your plea to the resisting without violence. I will adjudge you guilty of that. You'll be sentenced to time served. I will impose court costs and a $50 cost of prosecution to the state. It's a total of $273, and then I will give you 24 months or 2 years to get that paid. State have an announcement?
Yeah, state has an announcement as to count 2. State announces a no information.
All righty, in that case, and then I'll take no action on the bond case. All righty. Good morning, afternoon. Your name, ma'am?
Ebony Gordon.
Ms. Gordon, you're here today because you were arrested on 2 charges, resisting an officer without violence and possession of cannabis. I did read over those charging affidavit. I do find sufficient probable cause on those charges.
And Your Honor, Ms. Gordon, the offer from the state as to the resisting an officer without violence is an adjudication of guilt, credit, time served, and court costs. Ms. Gordon would like to accept and enter a plea of no contest.
All right, Ms. Gordon, is that what you want to do? Enter a plea of no contest to this charge? Yes, sir. Are you under the influence of any drugs or alcohol today? Have you suffered from or been treated for any mental illness in the past? No. You understood the rights in this form and signed it. Do you have any questions about those rights? No. You understand that this is punishable by up to a year in the county jail, up to a $1,000 fine, and that the entry of your plea would result in deportation if you're not a citizen. All right, do you find sufficient factual basis to accept your plea? I will adjudge you guilty of the charge of resisting without violence. If you sense the time that you have served, I'll impose court costs and a $50 cost of prosecution. That's going to be a total of $273, and I'll give you 24 months to get that paid. Okay? State have an announcement.
State has an announcement as to count 2 for Mrs. Gordon of a no information.
All right, you're all set. Be released. I'll take no action on the bond case. Your name, sir?
Michael Hippolyte.
Mr. Hippolyte, you're here today because state of Florida, or because you were arrested on charge of open carrying of a weapon or a firearm. I have reviewed the charging affidavit, and I do find sufficient probable cause to set bond in the amount of $500. And did you want a public defender appointed to represent you? You want a lawyer?
Yes.
All right, I'll appoint a public defender to represent you.
I already did my bill. And I got one thing. They never read me my Miranda rights.
That's okay, as long as you make a statement, or they don't question you. Well, it's not even.
All right, so what is this? Call them?
State the bond.
Oh, yeah, 500, yeah. Yeah, just state it.
Okay.
Your name, sir? Your name?
Oh, Stephen Laurent.
Mr. Laurent, you're here today because you're arrested on charges of disorderly conduct, brawling, fighting, or fighting. I reviewed the charging affidavit. I do find sufficient probable cause.
There was not an offer made by the state, Your Honor. I don't know why. Do we know why, Taylor?
It's up on the amount of
Because it's a battery?
Mine's is not battery. What, don't speak? I'm sorry.
Disorderly conduct. Mm-hmm. Depending on who was hit. Mm-hmm. Yeah, fighting.
This one I thought was kind of close. It does say that he disturbed his peace, but it doesn't say really how. Not sure. I didn't
see any hit. Would you have victim? I Your Honor, I would argue there's no PC. All it states is that he disturbed his peace. There's no,
I don't disagree with that. Unfortunately, then there's, I mean, he can bring it, if he doesn't bond out, we can bring it back tomorrow and see if they've got something to
Yes, Your Honor,
supplement.
that's what I would.
Okay. So, all right. And maybe in the meantime, the state takes a look. They might have an offer too tomorrow. I'll appoint a public defender. What that means, Mr. Laurent, is we're gonna, if you bond out, okay. If you don't bond out, we'll bring you back tomorrow and see if the state can supplement it. If they can't to establish it, then you'll get released without a bond tomorrow. Okay?
Until tomorrow.
Pay the bond.
Yeah.
I'll pay the bond.
Okay, go ahead.
I'm about to leave.
Yeah.
Don't worry.
They're gonna take you. You gotta call the building.
Your Honor, Nubine and McBride bonded.
All right.
Me?
Davis, Timothy Davis. What's that? We got Timothy Davis next. Nubine McBride bonded.
What happened with Joseph Roberto?
Okay, I just wanna make sure.
He bonded. And Wilson, Anthony Wilson? 2201-2462.
Bonded.
Thank you.
I already took them out of my stack. They didn't tell you nothing. All right, your name, sir?
Timothy Davis.
All right, Mr. Davis.
And, Your Honor, there is an offer of an adjudication of guilt, credit time served, no return to 421 East Kennedy Boulevard, and there's also a cost of investigation in the amount of $42.64 to, is that Edenville?
Eatonville.
Police Department. Mr. Davis would like to accept and enter a plea of no contest.
All right, Mr. Davis, is that correct? You want to enter a plea of no contest to this trespass charge?
Yes, sir.
Are you under the influence of any drugs or alcohol today?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
All right, you understood the rights in this form. Do you have any questions about those rights?
No, sir.
You understand this is punishable by up to a year in the county jail, up to $1,000 fine, and the entry of your plea would result in deportation if you're not a citizen. That's not what's going to happen. That's the maximum sentence. Do you understand that? All right. I do find sufficient factual basis. I will judge you guilty. Sentence to the time that you served in the Orange County Jail.
2 days.
2 days, was that?
Mm-hmm.
I will impose court costs and a $50 cost of prosecution. That's a total of $273, and I'll give you 24 months to pay that off, okay? Finally, you're not to return to 421 East Kennedy. Oh, and there's also $42.64 cost of investigation, not to Edenville. You're not to return to 421 East Kennedy, okay, for a period of 1 year. If you do go there at any time in the next year, you are subject to contempt citation. Okay? All righty, good luck. Are your name, ma'am?
Erica Hornsby.
All right, Ms. Hornsby, you're here because you were arrested for failing to appear on an open container charge.
And, Your Honor, the offer from the state is an adjudication of guilt, credit time served, and court costs. Ms. Hornsby would like to accept and enter a plea of no contest.
All right, Ms. Hornsby, is that right? You want to enter a plea of no contest to that open container?
Yes, please.
Are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
All right. You understand the rights on that form that you just signed? Do you have any questions about the rights?
Yes.
No?
Jackson, if you have any questions.
Any questions about the rights on the form?
Oh, okay. I don't believe so.
Okay. You understand?
I'm sorry, on the open container, is
Right.
that 22 MO 665?
No, the
I believe
179.
that was, civil justice.
22 MO 179.
We're only playing the 179,
The FTA or both?
just the FTA, not the violation.
The state's only making
It comes from the same thing.
So are we pleading to both? It's the same.
Because I was confused because,
Yeah, I mean, they gave her a violation. Who did that? How did that happen? I mean, doesn't it, when she pleads, doesn't it just goes, just goes away?
And she just be ROR'd as to the violation? If she
Once
pleads
the
to
case is closed,
failure to appear?
she did get picked up on it, so it's just like if she got arrested. I don't think, I mean, I want to make sure that if something needs to be done, we need to do something so that she gets released, but it seemed to me that it would be just, it's, you know, what says you guys in classifications? It looks like what happened is Judge Gibson had already signed April 25th, the violation of pretrial release. No, it looks like she failed to appear first, and then she signed the violation of PTR. So both of them just sort of were out there. That really shouldn't have happened, but because once she failed to appear, there's a capias. But the date on the PTR violation is, you guys did it on the 18th, she didn't sign it till the 25th. So that's what happened. But there's no need to really deal with that once the case is closed, right?
I mean, like Kirk said, it's two.
It's not a charge.
So I would just say plea on both.
but it's not a charge. I mean, in other words, it's like she failed to, it's not where, she's not pleading to failing to appear, she's pleading to the
Underlying.
open container.
Mhm.
And so once that's done, the failure to appear, she got arrested because she failed to appear. Now that that's over with, that should be taken care of. In other words, in some jurisdictions, they do charge
Mhm.
failure to appear, and they charge, violation of PTR as an actual offense, because you can. But we don't do that here. It's not an actual charge. It's still underneath the same case number.
Eventually go away.
Shouldn't be an issue. She should. I mean, my question is, what's gonna happen when we get done, she goes downstairs, and it's like, oh, I should be released, and they're like, well, there's this violation.
Yeah, because there's 2 court orders. It's gonna be 2 separate court orders. One court order.
But it's all under the same case. It's all under 179, and 179 is closed, and she was sentenced to time served. And we're not pleading, I mean, by that argument then, the failure to appear would still hold her in too, right? Because she's pleading to the one thing
That's what happened yesterday.
and resolving the case.
I'm not too sure, Your Honor.
Well, I mean, I guess it's like, anytime someone fails to appear and then they decide to plea, they're pleading to the underlying offense, and then they get released, right? Because the case says they're done and they're to be released as to this case. She agrees with me.
Yeah.
Okay, as long as-
So I think we're good. Right, yeah, yeah.
Yeah, that's what I'm saying.
Well, then I'll just say I dismiss or release her.
Oral.
I don't know I don't know really what to do.
It's oral.
Dismiss.
I mean, she's not being ROR'd because the case is, she's
Yeah, it's-
pled and she's done. She's getting time served. I don't want to think she's got to come back.
Mm-hmm.
All right, let's just do, I'm gonna do the plea, we'll judge her guilty, send her to time, we'll do that. And then as if it was failure to appears, we'll see, if she's not out tomorrow, we'll bring her back and then we'll make sure it gets done. I don't think it's gonna be an issue. All right, so, I will accept your plea, I'll judge you guilty, you'll be sentenced to time served, there'll be a court cost and a $50 cost of prosecution. That's a total of $273. I'll give you 24 months to pay that. And,
How many days?
I'm not too sure. One moment.
and just indicate that she's to be released, as to this case. That should do it, right? Yeah, right, and just say that the court orders that she has been sentenced and is to be released as to this case.
Released by the morning.
Okay?
4 days.
Okay. All right.
And there's comp issues, Your Honor, so I would waive the appearance.
All right. And we'll, that's the trespass that bond, $100. And, no action on the other bonds he's on. Your name, sir?
Elvis Ayala.
Mr. Ayala, you're here today because you were arrested on a warrant for failing to appear on your driving license suspended charge. The bond is set at $2,000.
Your Honor, the state did convey an offer of an adjudication credit time served.
I believe he's on probation.
You're on probation now?
Yes.
Yeah, then that'd be a violation for you. Okay. Your name, sir?
Cameron Brown.
Mr. Brown, you're here today because you were arrested for a charge of no valid driver's license.
Yes, sir.
Yes, Your Honor, the offer from the state is an adjudication of guilt, credit time served, and court costs. Mr. Brown would like to accept and enter plea of no contest.
We want to enter plea of no contest then to time served, Mr. Brown? Yes?
Yes.
Are you under the influence of any drugs or alcohol?
No, sir.
Have you suffered from or been treated for any mental illness in the past?
No, sir.
This plea form, you understood the rights. Do you have any questions about the rights on there?
No, sir.
Understand that this is punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes, sir.
All right, do you find sufficient factual basis? I'll judge you guilty of the charge of no valid driver's license, sentence to time served, unposed court costs, $50 cost of prosecutions, total of $306, and I'll give you 24 months to get that paid.
Thank you, sir.
Okay? You'll be released as to this case. No. Your name, sir?
Anel email.
All right, sir, you're here for several things. You failed to appear, you were supposed to come see me, looks like on the 19th of May. Failed to appear on attaching a tag not assigned. And you failed to appear on, probably driving license suspended. Yeah, driving license suspended. In the attaching a tag, there's a $100 bond, and the driving license suspended, a $2,000 bond.
I don't have any money right now. I ain't working.
What's that?
I don't have no money. I'm not working.
Let me see, what has he got here? Should be driving record in here. We might be able to take care of those.
Your Honor, state did convey an offer of a withhold on both.
Yeah.
I don't see any
I want to make
previous
sure
history.
he's not. Yeah, he can take a hit from driving license suspended. That's fine. Is that what he wants to do?
Yes, Your Honor.
All right, so you're going to enter pleas of no contest to both the charges, the attaching a tag and the driving license suspended. Are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
All right, the plea form there has those rights. You understand those rights. Do you have any questions about the rights that you're giving up?
No.
You understand that both of these are punishable by up to 60 days in jail, up to a $500 fine, and that the entry of your plea could be used against you in any deportation proceeding if you're not a citizen. All right? I do find sufficient factual basis to accept your plea. As to the no valid driver's license, I will withhold adjudication, impose court costs, $50 cost of prosecution. That's a total of $301. I'll give you 24 months to pay that. As to the driving license suspended, I will withhold adjudication, court costs, $50 cost of prosecution, again, $301, 24 months to pay that. So it's $301 on each, and I gave you 2 years to get them both paid off. You'll be released as to these cases.
He has 6 days, 6 days time served. 6.
Your name, sir?
Isaiah Morgan.
All right.
And Your Honor, the offer from the state is a withhold credit time served and court costs to resolve the no valid driver's license.
All right, Mr. Morgan, you're here on a no valid driver's license. I have reviewed the charging affidavit. There is sufficient probable cause. I'm sure you heard what the attorney just said, that if you want to enter a plea, it would be time served and court costs. Do you want to do that?
Yes.
Want to enter a plea of no contest then? All right. Are you under the influence of any drugs or alcohol today?
No.
Have you suffered from or been treated for any mental illness in the past?
No.
You understood the rights in this form and then signed it. Do you have any questions about the rights on that form?
No.
You understand this is punishable by a maximum of 60 days in jail, up to a $500 fine, and that the entry of your plea would result in deportation if you're not a citizen.
Yes.
All right, to find sufficient factual basis, I'll withhold adjudication, send you to time served, court costs, and a $50 cost of prosecution. Now, the total on that is going to be $301, and I'll give you 24 months to make that, to get that paid, okay? You'll be released as to this case. Your name, sir?
Rafe Richardson.
Mr. Richardson, you're here today because you're arrested on a charge of driving under the influence with property damage or personal injury. I've reviewed the charging affidavit. I do find that there is sufficient probable cause.
I'm sorry. Can you repeat that?
Yes, you are here because you were arrested on a charge of driving under the influence with property damage or personal injury or a prior conviction. And I did read the charging affidavit, and I do find that there's sufficient probable cause. So bond will be set or stayed in the amount of $1,000 You're not to drive without a valid Florida driver's license. You're not to possess or use any drugs or alcohol.
Yes, sir.
If you do bond out, and I'll appoint a public defender to represent you. Your name, sir?
Joash,
Read this one. Oh, this is out of county. I gotta go to the other thing. It's not? Is it not under? Oh, okay. It starts with Alan Kirk. I got confused. All right, your name, sir? I'm sorry. It's Curtis or Josh Errol. Is that right?
Yes, Your Honor.
All righty. You're here today you're arrested on in a case for failing to appear, and that was on a burglary of an unoccupied structure, a grand theft, and a criminal mischief. Bonds are as follows: in the burglary, it's $1,500; in the grand theft, it's $1,500; and finally $500 for the criminal mischief. I will appoint a public defender to represent you. You don't have all the rest of these? All the rest of them. Not ours. Not our problem. At least not yet. Not today. Your name, ma'am?
Michelle Blameyer.
Hi, Ms. Blameyer, are you here today because you're arrested on 2 charges, possession of methamphetamine and possession of burglary tools? I have reviewed the charging affidavit. I do find sufficient probable cause. Bond on the possession of methamphetamine is $1,000, possession of burglary tools $500, and I will appoint a public defender to represent you. Your name, sir?
Hector Carrion.
Or sir, you're here today because you failed to appear in a case, and there's no bond on that failure to appear. I will appoint a public defender if there wasn't one previously appointed.
There you go.
Your name, sir?
Dante Chance.
Mr. Chance, you're here today because you were arrested for a driving while license suspended. I have reviewed the charging affidavit, and I do find sufficient probable cause. Let's see what they put that bond down. Yeah, I don't know why. Hang on. I'll reduce that bond to $500 and appoint a public defender.
Does he not qualify? Oh, Your Honor, he qualifies for pretrial release.
Oh, does he?
Yes, I would.
Okay, that's fine. Did you want to go pretrial release in instead of having a bond to post?
Yes.
All right, I'll release you with pretrial release conditions and appoint the public defender.
And no conditions?
No driving without a license, no alcohol.
Yes, sir.
Yeah, you're not supposed to drive, okay.
Yes, sir.
Your name's?
Chase Davis.
All right, Ms. Davis, you're here because you're arrested on the charge of possession of fentanyl. I have reviewed the charging affidavit. I do find sufficient probable cause. Bond set in the amount of $1,000, and I will appoint a public defender for you.
Your Honor, Christopher East is medical.
Mr. East case, failure to appear. All right, as the burglary structure, set bond $2,500, burglary conveyance $1,000. We'll stay all the rest of the bonds. Grand theft $1,000, grand theft $1,000, grand theft $1,000.
Your Honor, you would ask for no contact and no return.
No return to the alleged victim's place, and also no contact with the victim. And appoint a public defender.
Kind of mistake.
Your name, sir?
Ernst.
first name?
Myron.
All right, Mr. Ernst, you're here. First of all, there was a, court issued a probable cause warrant for the charge of attempted robbery in 2018 CF 14866AO.
I know.
Looks like it originally was, and the bond on that is $25,000.
There's a photo lineup.
You have a second case, 2018 CF 14923AO. And in that case, there also was a, is that the same case?
Pardon?
They can still take a case.
After they tell us dismissed in federal court?
Yeah, in that case, there also was a probable cause warrant issued. And, for the same charge.
All the information.
And bond on that is also $25,000.
Yeah, I believe the 14923 is not an attempt, it's just a robbery with a firearm, so it should be set at no bond as it is a PBL.
Until you have a federal detainer right now, they're holding you for these two. I don't know what happened.
Your Honor, there's some kind of big mistake here.
14923 was filed
Yes.
as a robbery with a firearm, which
Yeah, I
is a
see.
PBL.
Yep.
Two states asking that it stay at no bond.
I believe the issue is, and I can't see it, but my client stated that he showed up for federal court for this and it was dropped.
And then they had me, after they told me it was dropped in open court with my lawyer and the prosecutor, they had me to plead guilty to these charges in federal court.
Okay, here's the thing. Bank robbery, there's concurrent jurisdiction. What that means is you could be charged in federal court and in state court on a bank robbery. Same crime. You can still, the both of them can go because there are some offenses that do have concurrent jurisdiction. Okay.
Our office has also spoken to the AUSA on that case. It said he already told the defendant that when he asked us to drop the charges, we said no. And he was sentenced to 10 years federally for
12.
virtually the same conduct. So this has already been discussed.
So, I mean, I'll appoint a public defender on both cases. They can certainly take a look at that and dig in on that issue and see what they can do. And as to, the state is correct, the 2018 14923 is not an attempt, so there is no bond on that. Your name, sir?
Jason Fernandez.
All right, Mr. Fernandez, you're here today because there was a warrant issued for you, a probable cause warrant for charge of burglary, conveyance, and petty theft with 2 prior convictions. I have read it is correct, so the bond is on the burglary would be $5,000 and on the petty theft $500, and I'll appoint a public defender to represent you.
I've never been arrested on this charge. I've never had no charge. I don't understand where this even.
Well, it could be the public defense. Oh, that's a. You mean this actual charge? What it is an affidavit was taken to the court, and then an affidavit was based upon that a warrant was issued. So you never got arrested. This was the first time. Yes, that's correct.
Okay.
In other words, they developed the case.
But they waited a year and a half.
You were in prison.
Yeah.
Your Honor, Darius Fudge is medical.
All right, Mr. Fudge, in Mr. Fudge's case, as to count 1, kidnapping with a firearm, no bond, armed burglary with a dwelling with firearm, no bond, and resisting without violence, 100. Want a public defender to represent him.
Your Honor, state would ask for no contact.
No contact with alleged victim, no return to the scene. Your name, sir? Your name?
Oscar Alejandro Infante.
All right, sir, you're here today because you were arrested on 2 charges, grand theft, 3rd degree of a motor vehicle, and resisting an officer without violence. I have reviewed the charging affidavit. I do find sufficient probable cause. going to stay those bonds, $1,000 on the grand theft, $500 on the resisting without violence. I will appoint a public defender to represent you, so I have a lawyer. Your name, sir?
David Garfield.
All right, sir, you're here today because you're arrested on 3 charges, carjacking with a firearm, robbery, sudden snatching, and grand theft third-degree motor vehicle. I have reviewed the charging affidavit. I do find sufficient probable cause. The carjacking with a firearm would be no bond. Robbery would be $1,000, and the grand theft is, I'm going to reduce that to $1,000 as well. And I will appoint a public defender to represent you.
Your Honor, state would ask for no contact with victims or co-defendants.
No contact with alleged victims, no contact with the co-defendants.
He's also out on bond.
Anthony Wilson and Idalberto Lau, LAO.
Your Honor, he's also out on bond on a petty theft.
Oh, revoke the bond, no bond. Your name, ma'am?
Bridget Gary.
All right, ma'am, you're here today because you were arrested for a couple of charges, aggravated assault with a firearm and grand theft third degree of a firearm. I have reviewed the charging affidavit, and I do find that there's sufficient probable cause. All right, as to the aggravated assault, there is no bond, and the grand theft to be $150. You currently are out on bond for,
Okay.
you know what these are? It
She's
says
been,
active cases. She really on a release for those, or?
she's been deemed in,
There was charges that were dropped.
they're not, I don't think they were dropped. They're in comp proceedings, Your Honor.
Oh, okay.
So I'd ask that you take,
I'll take no action on those.
Your
however,
Honor, as to count 1, she is entitled to a bond. It's not a PBL. So state would ask that you set a reasonable bond.
All right, I'll set a $5,000 on a public defender.
And state would ask for no contact.
No
and
contact with
return.
the alleged victim. And it was in a car, so. Allegedly. Your name, sir?
George Goins.
Mr. Goins, you're here today because, let's see, looks like you failed to appear.
I didn't know I was supposed to go to court,
stop
sir.
talking.
What's that? Well, it looks like you failed to appear on your possession of cocaine and the, what was your other charge? And possession of drug paraphernalia, the bond on that is $500 and $100. Judge LeBlanc was very nice to you. One of his final acts, he's retired. And so I'll appoint a public defender for you. Your name, sir?
Joshua Jackson.
Mr. Jackson, you're here today because you're arrested on a charge of carrying concealed firearm possession of cannabis less than 20 grams. I have reviewed the charging affidavit. I do find there's sufficient probable cause. The bond on the carrying concealed firearms, $2,500, possession of cannabis, $100, and I'll appoint a public defender for you. Your name, sir?
Schneider, Jean-Pierre.
Hi, Mr. Jean-Pierre, you're here today because you're arrested on a charge of carrying concealed firearm. I have reviewed the charging affidavit. I do find sufficient probable cause. Bond set in the amount of $2,500, and I will appoint a public defender to represent you. You're all set.
Oh, I didn't know. I'm also, I didn't hear you.
Oh, I said that I have reviewed the charging affidavit, and there is sufficient probable cause for the carrying concealed firearm. Bond is set in the amount of $2,500, and I will appoint a public defender to represent you, so you have a lawyer.
Your Honor, he qualifies for pretrial release. I would ask for pretrial release, given he has no criminal history.
All right.
State has no objection.
Okay, I'll release, actually, I'm not gonna require a bond. I'm gonna release you through pretrial release. Okay, so you're gonna have to make sure you keep in contact with them and do what they ask you to do, but I will release you with PTR, okay? Yes,
sir.
All righty, good luck.
Any conditions, Your Honor?
No weapons, no guns.
Thank you.
Your name, ma'am?
Jessica Jones.
Let's see. All right, Ms. Jones, you're here today because you're arrested on a charge of attempted robbery. There's a bond, I have reviewed the charging affidavit. There is sufficient probable cause. There's a $1,000 bond on that, and I will appoint a public defender to represent you.
Your Honor, State would ask for no return to the 7-Eleven.
All right, and no return to that 7-Eleven, okay, where this occurred, allegedly.
Your Honor, Judy Kelly is mental health.
So let's start at the top with Ms. Kelly. 2016 CF 12681 on the failure to appear, issue a KPS. I mean, that looks like it's no bond. Are all of them no bonds?
All the failure to appear is yes, Your Honor.
Yeah, all right. So, and all of her failure to appear is 2020 CF 9444 AO, failure to appear, no bond. 2021 CF 4745 AO, failure to appear, no bond. 2022 MM 3635 AO. On the battery charge, it'll be a $500 bond. No contact with Richard Francis. No return to 2803 West Arlington Street, 151. No guns, no weapons, no drugs, no alcohol. And point of public defender on all the cases that she's not had an appointment yet. All right, your name, ma'am?
Magali Okanya.
You are here. You were arrested on a charge of carrying concealed firearm. I have reviewed the charging affidavit and do find sufficient probable cause. Bonds set in the amount of $2,500, and I'll appoint a public defender for you so you have a lawyer. Your name, sir? Your name?
Brian Perez Cave.
All right, sir, you're here because you're arrested on a charge of possession of fentanyl. I have reviewed the charging affidavit, and there is sufficient probable cause. Bond set in the amount of $1,000, and I will appoint a public defender to represent you.
Thank you.
Your name, sir?
David Proudfoot.
All right, Mr. Proudfoot, you're here for, looks like 3 cases. First of all, in 2022 CF 6248 AO, you were arrested on a charge of grand theft 3rd degree. I do find that there's sufficient probable cause. Bond set in the amount of $1,500 on that. The next case is 2022 CF 6244. And in that case, you're charged with scheme to defraud and petty theft. I have reviewed the charging affidavit. Actually, that was under that was a probable cause warrant signed by another judge. And the bonds on those 2 charges are $1,500 for the scheme to defraud, $500 for the petty theft. I appoint a public defender for that charge, that case as well. And then finally, you have 2022 CF 6247 AO. And in that case, you're charged with grand theft 3rd degree and obstruction by false information, or you're arrested on those charges. I did review the charging affidavit, and I did find sufficient probable cause. The grand theft 3rd degree, more than $5,000, less than $10,000, the bond is $5,000, and the obstruction by false information is $1,000. And I will appoint a public defender to represent you on that case as well.
Your Honor, State would ask for a no return to Walt Disney properties.
Yeah, you're not to return to the Walt Disney properties. If you do go back there, you'll be subject to contempt citation.
Yes, sir.
All right. Yep. Yeah, they're all from there. Your name?
Megan Shellman.
What happened with Redding? We already did have that. All right, Ms. Shellman.
Yes, sir.
You're here because you're arrested on 3 charges. Possession of methamphetamine with intent, destruction of evidence, and resisting an officer without violence. I have reviewed the charging affidavit. I do find sufficient probable cause. On possession of meth with intent, be $1,000 bond. Destruction of evidence, I'll reduce that to $500 bond. Resisting an officer without violence, I'll reduce that to $100 bond. And I will appoint a public defender to represent you. Let's see, what is this other case?
One moment.
She's out on bond.
Yeah, I'm looking at it, hang on. Her bond on that other case, it doesn't show.
Her fleeing, I believe, came in at 2,500. Wait, no. Her Dwillis came in at 2,500.
All right, I will revoke that bond, set a new bond on the fleeing at $5,000 and $500 on the Dwillis.
Thank you so much. Thank you, sir.
Your name, sir? Your name?
Corey Taylor?
I'm Mr. Taylor, you're here, first of all, because you were arrested on a number of charges. I have reviewed the charging affidavit, and I do find there is sufficient probable cause as follows. Possession of methamphetamine, the bond's at $1,000. Possession of firearm by convicted felon, the bond is $4,000. Possession of ammunition by convicted felon, I'm going to reduce that to $1,000. Fraud or impersonation, that's a $1,000 bond. Resisting officer without violence, $500, and possession of drug paraphernalia reduced to $100. And I will appoint a public defender to represent you on those charges. You're also out on bond in 2021 MM 4911AO, the petty theft and resisting without violence, revoke that, and there'll be no bond on that. Appoint a public defender.
On the out-on-bond, Your Honor, he has a private.
Yeah, it's, okay, Gary.
Well, it's RCC.
I think that's RCC, isn't it? Yeah.
Oh, RCC, sorry.
Your name, sir?
Maurice Torres.
All right, Mr. Torres, you're here because you're arrested on a probable cause warrant for the charge of aggravated battery with the firearm, discharging the firearm. There is no bond on that.
Your Honor, it is an F2, so he is entitled to one.
Okay, yeah. Did he not? All right. All right, I'll set bond in the amount of $10,000 and appoint a public defender to represent you. If you do bond out, you're not to have any contact with any of the witnesses or the alleged victims.
Sir,
And possess no weapons.
there's no way to lower it. I mean, I got 2 kids and a grandson I gotta get home to.
Our state would object to being lower. He has several VOPs, several failures to appear, and other violent history.
I would argue, Your Honor, he has some criminal history. However, his last conviction was back in 2016, along with his last failure to appear was in 2014. So I'd ask that you consider that and the fact that he has lived here in Orlando for over a year.
I've been living in the same house 37 years, man.
When setting the bond, I would ask that you consider reducing the bond to $5,000, Your Honor.
He had a violent arrest in 2019 of another.
What was that?
ag-bat.
What was the 2019?
An ag-bat on a pregnant person. It was no build.
It's okay.
All I got is a possession and a dentist on the property, sir.
And how many failure to appears?
It's 4.
4.
I don't know, I turned
5.
myself in last time.
5.
On
5
the
total.
last charge.
All right, I'm gonna leave it at 10, and then whoever, whatever, I don't know what division this is gonna go to. It looks like it's Judge Strobridge, you can ask her.
All right.
Okay.
Mhm. Your name, sir?
Joseph Vance.
Mr. Vance, you're here because you were arrested on a charge of trafficking in heroin, more than 4 and less than 14 grams. I do find sufficient probable cause for that. Bond set in the amount of $50,000. I will appoint a public defender to represent you. And currently you're out on bond in 2021 CF 14348. Fleeing attempting to elude. I wrote that bond, no bond.
Yeah, it's a second case as well, Dwillis, Your Honor.
Oh, yeah, same thing. No bond.
Staying the.
Yeah. No bond. Revoke it.
No, he has the second
he
new
has a
case.
drive, a new.
Okay, I'm talking about the old case.
Okay.
Oh, you're asking me about what the bond is on that one. Just on the new one, the driving license suspended and make it 500. And a public defender again on that new case. Your name?
Tracy Young.
Young, you're here today because you're arrested for two things. First of all, possession of methamphetamine. Second of all, possession of cocaine. I reviewed the charging affidavit. There is sufficient probable cause as to the possession of methamphetamine, bond set in the amount of $1,000, and possession of cocaine, $150, and I will appoint a public defender to represent you.
Good afternoon, Your Honor. This is Laura Bretaña, Spanish interpreter, previously sworn.
Good afternoon. Defendant is wearing the headset.
Sí, escucho.
There is contact, Your Honor.
All right, your name, sir?
Misael Ruiz Pérez.
Misael Ruiz Pérez.
All right, sir, you're here today because you were arrested on a charge of neglect of a child. I have reviewed the charging affidavit, and I do find that there is sufficient probable cause. Bond is set in the amount of $2,500. I'll appoint a public defender to represent you. And if you do bond out, you are not to have contact with the child in this case or any other witnesses. I believe the child is Leighton, Leighton.
I believe DCF was also called.
We do comply with any plan set in place by DCF because I believe
Okay.
they're working.
Yeah, and follow any DCF plan if you do bond out, if you want to see the child. Alrighty, thank you, sir.
¿Está bien?
Yes.
And that's it. Thank you, ma'am.
Thank you, Your Honor.
Oh. Had some weird ones today. I'd have 93 tomorrow. How about it? You and me will agree. They're not having 93. All right.
Okay.
Nothing else? I'm good? All right.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.